Wait, are we live now? Okay. Hey, everybody. This is awkward. So, Katt's making me do the introduction today. I probably should have listened more carefully when she was doing the previous introduction, so I'd know what to say. Oh, I can hear myself. Okay. Yeah. So we're going to be looking at two oral arguments, both of which were argued by Brian Steele yesterday before the Georgia Supreme Court. I'm specifically not good. I don't want to tell you guys anything about the first case because it is a kind of a wild fact pattern. Um, It will. I really don't want to say anything more than that. But it starts wild and then it gets wilder. Um, it is a murder case. The defendant appellant now was acquitted of murder, but the jury hung on the remaining charges. He was then convicted on felony murder, which is something that's been kind of a hot topic lately. Felony murder as a substitute for just a straight murder conviction. And the case will turn on two justification defenses. There's no dispute that the defendant shot the victim in this case. But as you will see, the justification defense is quite, I think, quite reasonable. And I'm curious to see what you guys think if you share that sentiment. And yeah, with that, I think we can get into Medina. We'll give a little bit more context for Larkins, the second case we'll watch.
Sounds good. And I did link in the description over here, at least, to the briefs. But remember, you can always find them on the Georgia Supreme Court website just by going up to this little oral arguments thing in the menu and going to case announcements. And they'll give you links to the upcoming cases, briefs and replies, and all of that good stuff. So for this one, we're just going to get right into the video. And guys in the chat, rate Jim's intro on a scale of 1 to 10. I think you did really well, Jim.
Thank you.
All right, so let's hit this play button. We'll get some captions.
There's one time where I was asked to speak at it was at a wedding. And afterwards, everyone was like, "You did so well." And I'm like, "Thanks." And they'd be like, for a guy, usually guys just show up and just wing it. I'm like, I'm literally professionally trained for this.
You can't say thank you too quickly.
Thank you, everybody.
I want you to know the EJF voted 13 out of 10 in both chats. You can't vote twice. No, I'm kidding. All right.
Ooh, so I should probably open my chat. I don't have your chat open.
All right. Well, you can't see the chats in StreamYard?
Oh, yeah, that's true. I forgot about that.
Well, chat, just in case you ever want to know, if any of you in the chat ever want to learn how to stream, I've struggled through it. Let me know. I will help you learn little things like how to see the chat in things like StreamYard. Always willing to help. I have captions turned on here. We'll see if they pick up when we start playing them. Otherwise, chat, let me know if there's no captions for my YouTube video. And if we don't have them here, I'll sort it out. We'll get closed captions for you guys. So here we go.
A0362, Terrance Medina versus the state. Brian Steele for appellant. Samuel.
It'll get louder in a second. No need to panic yet. No, there's that silver hair. There's that silver fox.
Good morning, Mr. Steele, when you're ready.
Good morning, Mr. Chief Justice. Good morning, everyone. Thank you so much for allowing me to appear before this honorable court. I am Brian Steele, and I have the honor of representing appellant, the grand jury of DeKalb County indicted appellant for murder, felony murder, aggravated assault, possession of a firearm during the commission of a crime. He went to trial with a great lawyer. The Honorable Dwight Thomas was acquitted at the first trial of malice murder. The other counts hung. This honorable court actually had an interim appeal on a plea and bar. The case then went to retrial on the remaining 3 counts, and appellant was convicted, sentenced to life with the possibility of parole plus 5 years. The facts are as follows. Appellant grew up in this home in DeKalb County, Georgia, with his family, siblings, and his mother and father. That home has been his childhood home to the home that he had until the day of the shooting and beyond. His mother, God forbid, passed away in 2012. His father went through some memory loss. Appellant was living in Athens, Georgia, with his wife and father, and he was working in DeKalb County, not far from this home. He would go to the home frequently, and there were a lot of people who were entering the home who were not allowed to enter the home, who were forcibly entering the home and stealing items and taking all their valuables there and tossing them around and rummaging through and stealing items. Appellant had the home boarded up, except for the front door. All the windows boarded up. The back of the house is boarded up to prevent people from coming in. On July 20th of 2015, appellant, he's armed with a gun. He bought a gun. Not long before, he walked into his home. He parked up the block, walked into his home. He was scared. There's perpetrators who go into the home at times. It's early morning hours. It's before he's going to work. And he saw the front door was still locked. He used his key to get in. He walked upstairs to his childhood room. He was preparing this house to be lived in, as I said, by his father and his wife, and they were going to move from Athens to DeKalb County.
Counsel, can we turn to the first enumeration of error about the jury charge on justification? If I understand your argument correctly, you don't contend that any of the specific charges were incorrect. You're just saying that the way that the trial court gave the charges, the order that the trial court gave the charges made it confusing. Is that correct?
Correct. So what happens is the trial court defines the affirmative defenses, and there are two. There's self-defense and there's defensive habitation. And then the trial court starts going through and gives examples of defines what is habitation. And then the trial court defines self-defense and when a person can use deadly force. Right after that, the trial court then gives the instruction that on defensive habitation, a defendant is justified in using force against another that is intended to cause serious bodily injury or death when, and then one, the other person is making or has made unlawful and forcible entry into the residence. Two, the defendant knows or has reason to believe the other person is making or has made unlawful and forcible entry into the home. And three, the other person is not a member of the family or household. Immediately after that, there's no breaks, there's no demarcation. The trial court explains that after the state has the burden of disproving justification, that for the defendant's threat or use of force to be justified, the defendant must believe that his threat or force was necessary.
So
that
even
is
though
not
it's
part.
maybe inartful, if it's not wrong, what's the harm? Maybe an inartful, maybe could have been broken up, explained what was coming, with the title of the actual instruction, but if it's not wrong, then how is it harmful?
It's not inartful. It is wrong. It's making the defensive habitation have restrictions that it does not have.
Oh, can we pause 1 second?
The restriction.
I feel like this is one thing Brian does really well. I don't know if it's Brian. I've
Just
never
one
met him.
thing.
We're not on a first name basis, but I feel like more lawyers are so afraid to tell judges they're wrong that they just end up being like, "Oh, I wouldn't quite say it that way," and give this long, roundabout way of saying I disagree. Whereas has the, obviously he has credibility, but I think it's useful to just disagree if you disagree. I really like that he does that.
You also, I feel like you have to make that adjustment when you're working in an arena where there's time limits on the arguments. And this one goes a little bit longer, you guys. This is like 40 minutes and change. But it helps cut down the mannerisms and the small talk that eat up that time.
Yep. Confidence. That's what I was looking for.
That's an easy one to look for. So, yes, my close personal friend, Brian.
From defense of self and place that upon the same footing that a person would need to employ defensive habitation.
But counsel, 16.323 in the introductory language does say for defensive habitation, the person is justified he or she reasonably believes that such threat or force is necessary to prevent or terminate the unlawful entry. I mean, doesn't that include a reasonably necessary use of force element in the defense of habitation? So I don't see that as being inconsistent with what the trial court charged.
No, excessive force is not part of defense of habitation in Benham, BENHAM.
Okay, well, I understand this excessive force was at the end of this whole long charge, but I mean, you were previously arguing about that right after the defense of habitation charge that you pointed out, right after that, the trial court talked about the force has to be reasonably necessary, and you're saying that that is somehow caused the defense of habitation charge to be wrong?
I'm saying the entire charge, it's mixed together. It's excessive force, it's no duty
Confusing.
to retreat. You can't retreat if you're you have to retreat, or you can't stand your ground if you're the aggressor. All that does not come into play with defense of habitation. So I was getting to the list, but there's a list after defense of habitation that excludes the defense of habitation from being used. So I don't think that it's just a disorganized or confusing. I think that it is totally erroneous to a jury.
Mr. Steele, can we turn to enumeration 3? My understanding of your argument there is the trial court's use of the phrase prima facie case on the part of the state reduced the burden of proof that the jury was instructed that the state had to satisfy. And that, I don't know that I've seen a jury charge in a criminal case before where the state's burden is referred to as a prima facie case. So that does seem to have some heft to it. The state makes the point that the objection at trial to that instruction was not on the ground that it reduced the state's burden, and so plain error would be the standard that we're applying. What is your response to that?
Well, plain error would apply in all matters, but I believe that it was objected to properly by the trial lawyer. The state is saying that the exact phrase that I have targeted is not targeted by the trial lawyer, and I thought it is. And if I'm wrong, the court will tell me, but I still think that the trial counsel did properly preserve the prima facie portion of the charge.
In the event that that was not properly preserved, what is your best argument on harmfulness under the harm prong of plain error?
So the charge goes into, the state is saying, and the state below, the trial prosecutor is saying that there's this and or. And means or, and they are targeting the count of possession of a firearm during the commission of a crime. But that's not explained to the jury. So instead, what the jurors are told is that if a crime can be committed in separate ways or methods, then the crime charged being committed in more ways, more than one way or method, the crime can be charged in a conjunctively using the word and list all the ways. However, the state is not required to prove all such separate ways or methods alleged in the indictment. Rather, the state must make a prima facie case by proof of any one of these ways or methods. The aggravated assault count, which is the predicate for the felony murder, the court gave 2 different ways to commit aggravated assault: by placing someone in reasonable fear or apprehension of receiving a serious bodily injury, or by actual injury with a deadly weapon. So the way I read that is a person who's not skilled like this court and say, well, it's said in the indictment, then the charge itself could be applied to the lower standard of prima facie. The charge is that's more confusing to me. I think that the first issue is just wrong. It blended together. There's no place to have in a criminal case that I could find. I can't find any case that talks about prima facie in a jury instruction when you talk about elements of an offense. Now, to be fair,
Yeah,
the
that's
trial
wild.
court did charge burden of proof, reasonable doubt, presumption. I'm not saying it's not. I'm just saying it is. This charge, I think, corrupted the entire instruction, and that would be the error.
So when we look at other cases where we've assessed the impact of a charge that invites the jury to convict based on less than reasonable doubt. And in particular, I'm thinking of I believe it's the DeKalb case where the reference was below 50%, which was even below a preponderance. Even with an instruction that obviously wrong, we still look to the evidence and whether, given the evidence at trial, that instruction would reasonably have, could a reasonable jury have found that the evidence was in fact below a preponderance? And in that case, we said, given the nature of the evidence in the state's case, yes. But what is the evidence here that would have invited the jury to convict based on a belief that a prima facie case was shown, but not beyond a reasonable doubt?
Appellant,
I was gonna say, this is the question that started this series of answers off was about what is the harm. And I'm kind of stuck on that because when you're dealing with an affirmative defense and what could be a faulty or confusing jury instruction, it just seems like there would inherently be harm. Like that is one of the most critical instructions to get right, because the only thing that's left there is, well, all of the elements are already agreed to by both parties, essentially stipulated to. Maybe did we, like, this is just a regular possession of a firearm, not possession of a firearm by convicted felon, right? So
This one, I believe it's use of a firearm during the commission of a felony. 106.
a use. Yep. Okay. So, I mean, like,
Yeah.
all of the charges, all three of these charges here, if the jury can't properly consider justification, all of the other elements have pretty much been by both parties affirmatively.
Yeah, the facts in this case, I should give a little background. The facts in this case were all, like, basically all agreed to. I don't think there was even any dispute as to what happened. There were a few things that were disputed, but like the broad strokes of what happened were, like you said, more or less agreed to.
Sweet. Let's get back to Brian.
as I said, comes into the home from the locked door, goes up the steps. He goes into his childhood room. The door was shut. He opens the door. According to appellant who testified, this is at volume 13, pages 483 to 534. Appellant states that there was a person who's naked in his bed in the room who gets up and starts reaching for something. Appellant pulls out his gun, which was on his person. Appellant tells the person, stop. The person said, who are you? Appellant states, I'm the homeowner. I'm calling the police. Stop. The deceased gets up, starts to come towards appellant. Appellant pushes the deceased back. The deceased comes again. Appellant pushes him back. The deceased then gets enraged, starts making motions, screaming, comes at appellant. Appellant fires. The deceased then drops back into the bed. Appellant goes, looks around the other parts of the house to see if there's other perpetrators, then calls 911 and tries to save the life of the deceased. The DeKalb County medical examiner testified.
I just want to reiterate those facts. So this guy owns the home. It's his childhood home. I think he inherited the home. It was vacant. It was abandoned. Yes, and there's like a naked guy in his childhood bedroom that like surprises him at like 7:30 in the morning. And we don't have any, like, he's the only one that knows what happened in that room. He testifies the guy came at him. That seems like I have a hard time getting to that, believing that somebody should be in prison for life based on those circumstances. That seems like murder on those facts is wild to me.
I feel like I'm primed to already think squatter situation, because if you guys know my background in real estate, I focus a lot on probate, estate planning, and, Medicaid look-back, clawbacks on houses. And a lot of time it's really not uncommon for people to have to worry about squatter issues when they inherit a property, because they probably live outside of the area where the property actually is. It's called ancillary probate. And you've got to do things like to protect yourself. You got to post. Sometimes you might want to have someone go post a sign that nobody should be entering this, just to make your case later that there's a squatter issue. So my brain is going there, and I'm still on the same page as you.
Yeah,
I think that it still seems reasonable that someone would go in that scenario, even though I think I might quickly think, hey, there's probably a squatter here. I still think it's reasonable. I would imagine that people that aren't used to dealing with squatters obviously would think it's more reasonable to, what is this naked guy in bed? And he's coming at me and now he's pushing me. It's not just you see a naked guy in bed and fire shots. If we take at face value what's being stated here, there was a physical altercation. Guy had reached for something next to bed. My brain goes to, you keep something next to you. If I'm squatting, breaking into someone's house, I would imagine I probably would be keeping a firearm near me. So I think it's very reasonable to think what they grabbed from the nightstand could have been a deadly weapon. So, oh boy.
Yeah, I just wanted to highlight those facts because they're kind of crazy.
Yeah, I think it's crazy. I think it seems like a reasonable thing to be scared if you're walking into your own house. But, you know, he was charged.
It did not happen like that because the bullet that struck the deceased, God forbid, right in his chest, severed the spine. So there's no more movement, according to that expert. The defense put up an expert who's a ballistic expert that said where the shell casing is, where the height and the trajectory, that person was standing and coming at appellant towards the door, exactly what appellant said. Appellant also called his own pathologist from the state of Alabama crime lab, who stated that the actual shooting could have happened exactly what appellant said, or it could have happened the way that the state says that the deceased is sitting in a bed. To be fair, the DeKalb County medical examiner also said that's just one position that the person was in bed. It could have happened in a lot of other ways.
But counsel, if I understand your recitation of the facts correctly, there was no question that the defendant committed the aggravated assault. I mean, he admitted doing that. The whole question was justification, right? I mean, so, and I don't, this
Which is why it would be
prima
extra
facie
harmful.
charge related only to the allegations in the indictment. It didn't relate to the justification defenses, right?
No, I respectfully disagree. First of all, I don't think the appellant committed aggravated assault. I don't think he committed any crime. I think I would do the same exact thing under appellant's situation. Appellant also put in good character. As far as this goes to the indictment, yes, I read it. It does say that. That's a very unique, wise way to look at this. Let's look at only the indictment and where it says for possession of firearm by a convicted felon for the crime of murder.
That was wrong.
And aggravated assault, and that's what they must be talking about with the separate ways. And let's ignore the jury instruction that aggravated assault can be committed in separate ways.
Separately, I always hate when a jury's asking about contemplating possession of a firearm by someone previously convicted of a felony that mention that they have a felony. They're not supposed to have the implication that they're not supposed to have a firearm. Like, I think it just sets up failure for the top level charges, even though the attached punishment for both is there's such a disparity between the sentencing, but it makes it so easy for the jury to take a leap and say, well, it can't be justified because he wasn't supposed to have that at all. So guilty on everything. But that's a side story here. That's a side issue.
I think that's the line that we should not be walking when we're giving jury instructions. This prima facie instruction has no right to be in this charge. And on these facts, if a reasonable juror reduced the burden of proof, how do we live with ourselves? I mean, under these facts of the case, this is not overwhelming evidence.
Were there any questions that were elicited? Did the jury have any questions regarding the burden of proof?
No, we have no insight. The judge never takes it back. There's no explanation. It's just the charge that's given. And the charge that's given is requested by the state. It's objected to by the lawyer for the appellant, and I understand the state's position, but I believe that it's a preserved issue. But even if it's not preserved, it is clear error to be talking about a prima facie case in a criminal case. I mean, that goes back to the founding before we were even a country. I mean, before we were a country, we didn't allow people to get convicted on prima facie evidence. People have to be certain, or whatever the right term is, you know, the highest standard that we can ever think of. I don't know how this happened.
Counsel, I mean, in the state's brief, and I guess I can ask the state too, the state claims that this and means or charge is very common commonly given, which I have seen that, I just haven't seen the prima facie language. I mean, is that something that this court, or I meant the trial court below, gives on a regular basis? I mean, do you have, or,
No, there are people on this bench that have tried so many cases. This is not common. I mean, I've had the honor, or I don't know, whatever. I've been involved in so many cases. This is outrageous. This never happens. I don't know who would request this, and I don't know. I just don't know how this happened. No, to answer your question directly, this is not normal. When it says and or, what the courts generally say, and this may not be perfect, but what the courts would say is, ladies and gentlemen, when the indictment alleges, when the grand jury alleges that a crime can be committed in two different manners, the state does not have to prove both manners beyond a reasonable doubt if they prove one to your satisfaction beyond a reasonable doubt. There's 0 times that we're talking about a prima facie case. So,
where do you think this language came from? Is it because state has to make a prima facie case to overcome a motion for directed verdict? Is that where that language comes from?
and also demurs, and I cited the case, it's Bartlett, B-A-R-T-L-E-T-T versus State 196, Georgia Appeal 174, Division 3, 1990. None of these cases are persuasive. I mean, if you just read the...
Is there like a blurring of lines between the standard for a preliminary hearing? Is this how this instruction is
I'm not sure.
muddied up?
It's just a weird way to get in there. I'm not sure how that happened, but
Because that language to me only makes sense at like a stand your ground, or I don't know if they have that in Georgia, if it would just be a preliminary hearing. That would be the applicable standard that the state would have to make.
Yeah.
They'd have to make the prima facie showing that this was not a justifiable use of whatever actually occurred.
Yep.
And somehow that language is bleeding into a trial, a jury trial instruction.
Yeah, I have no idea how that happened. I mean, it's like something that should jump off the page as incorrect, you would think. It's kind of just a strange phrase to see in a jury instruction.
The
in a
look
criminal
on
case.
confusion, like this is like confused or whatever. I
Yeah.
am confused. Confusion.
cases, nobody says, oh, this is a good jury instruction in a criminal case to talk about the proof that has to be put forth before the trial jury.
Was the jury ever told what prima facie case means?
Oh, Justice Land, I love your
Term that
voice.
lawyers understand, but how would they even know what that means?
I would know what prima facie case means before I was a lawyer. It does not mean beyond a reasonable doubt.
There you go. Steele just admitted he wasn't born this way.
He's just being
Prima
humble.
facie it's on first impression. I mean, it's so low, prima facie case. I mean, to say that it wasn't defined, if this honorable court writes that opinion, that's not giving much credit to the people who become jurors.
Let me ask you, was the instruction on the burden of beyond a reasonable doubt, was that the last instruction given after the prima facie language?
No, beyond reasonable doubt was before, but the court
Wait.
continues, and this is how this honorable court
This seems worse to me.
has read our pattern strategy, has authored, has criticized them or affirmed them. Beyond a reasonable doubt is mentioned throughout the charge. I don't want to say something different. It is clear that beyond a reasonable doubt is there. I'm just saying there's no right to put prima facie, and it's confusing. And we don't just ignore it. Jurors are listening to everything. That's what you taught me, that jurors are smart, and the jurors take these instructions, and they learn from the instructions, and that's the instruction. And I believe there's no way to isolate it, which is what the state wants to do too. Well, maybe it just goes to the gun count, so maybe the gun count's affected, but not the felony murder count. That is not fair. That is never said. If there are no other questions, can I reserve the time?
Of course. Mr. Dontremont.
I will say that I think that this part of the questioning goes better for Steele than Steele's actual oral arguments. Prima focaccia, yes. Yeah, I think that this part is really the more interesting part of the oral argument.
What was this guy's name? Did you catch it?
I don't remember actually.
Eh. Maybe they'll address him by his name again at some point. I'm scared to like rewind on this because it's not like a YouTube player and I don't want it to freeze or mess up. So maybe we'll
Yeah.
hear it. Maybe we'll hear it.
Eric Peters, maybe?
Didn't sound like that's what he said.
Clint Malcolm?
Mr. Chief Justice, Ms. Presiding Justice, good morning to you all, and may it please the court. The late Peter Tiersma, a law professor from Loyola who specialized in jury charges, held the opinion that litigants spend far too much time fighting about which jury charges to include in a given case and not nearly enough time fighting about how to give the charges or what the charges should say. In my own experience, I think that this bears out in trials throughout the state, and this is case is a perfect example of why we should bear that thing in mind. Because in their discussions of whether defensive habitation applied to Mr. Medina's case, and in their discussions of what a residence was, throughout the case, the parties focused on those terms and frankly lost the forest for the trees. And as this court reviews the allegations and the enumerations in these briefs, we need to be careful not to do the same thing. This case, beyond most others that I have ever briefed, requires the court to step back and take a larger view than the litigants did during trial. When the court does that, you will find that, let's just assume that the trial court, gave the instructions on affirmative defenses in a confusing manner or in a less than ideal manner. The fact of the matter is there was an independent reason why defensive habitation wouldn't apply to this case at all. And in conjunction with that, this case was always set up as a self-defense case from the defendant's initial 911 call all the way through his testimony. Defensive habitation was sort of tacked on at the end. In fact, it doesn't even get mentioned to the jury until maybe through examination and into closing arguments.
Okay, let's talk about this because, and I'd have to check Georgia statute, but I don't see how this is relevant. Defensive habitation, your case isn't supposed to argue the law to the jury throughout your case or while you're cross-examining during the state's case in chief. A justification charge comes into play if something on the record supports it. And in some states, the party has to actually request certain charges be included with the jury, and the judge may or may not have discretion. I don't know in Georgia if there's a standard like California has, and also I think similarly in Florida, where if there's anything on the record to support the justification, the court should include the instruction sua sponte. So I don't see how this would be relevant because we already heard Brian Steele say that in this case, the defense attorney had requested this and also objected to the wording. So this isn't an IAC issue. It can't be an IAC issue because the counsel already took issue with the wording of this instruction.
Yeah.
So
It doesn't appear in openings. It doesn't appear anywhere else. For the same reason, the charge,
Yeah, but the jury got the
the
charge.
court
So,
ended
like,
the discussion with Mr. Steele about the and means or charge, as we commonly know it, didn't lower the burden of proof because it sits in the middle of the jury charge, which the court has to consider as a whole. Beyond a reasonable doubt, the direct instruction came up before this charge was given, but the term beyond a reasonable doubt is throughout the charges, as Mr. Steele said, right up until the final instructions the jury is given about how to render their verdict. If you believe beyond a reasonable doubt that the defendant is guilty, indicate so. So
Is this reference to a prima facie case commonly given?
the charge itself, and I appreciate the opportunity to clarify my own words, the charge itself, I would say, is commonly given. That
and
language
means or
regarding,
charge.
yes.
But it does not typically contain the words prima facie case.
No, I personally have never seen this version of the charge given. It is not the one that I recommend our attorneys in DeKalb give, but just because the language was included doesn't make it wrong. The language is actually drawn from case law. I believe it's the Cal state that was directly referenced in the jury charge. And it is a description of how to assess the allegations in the indictment. And we're not necessarily trying to isolate this from the other charges because it's true for any charge that's done in the alternative. But even if you look at the language of the charge as the court did it, the term prima facie case came up in the description of, the state is not required to prove that the crime is committed in every way alleged, rather it makes a prima facie case by showing one of them. Jurors are reasonable and educated people capable of reading. And in this case, they didn't just listen to the court's instructions. They also had copies that they brought back with them into the jury room.
Right, but jurors,
Does the person on the street know what prima facie means?
No, and I actually think that that is more favorable to the state side, because when they see this term, it doesn't automatically signal to them that there is anything different
I
about
mean,
the
how
burden of
do
proof.
we know whether they know? I mean,
We-
prima facie is not an obscure term that only arises, you know, on rare cases. There are plenty of people on the street who may have familiarity with Latin, in fact.
That may be, but knowing Latin doesn't necessarily know what legal Latin means, because sometimes that doesn't track. Also, you, again, have to consider this charge as a whole, and the jury would have to consider the charge as a whole. Do we know exactly how they felt about the inclusion of this language? No, I can't tell you what was going through their minds, and unfortunately, they didn't ask any questions, so we don't know what was going through their minds. But they also saw woven throughout the jury charge what the state's burden was. The state embraced that burden in its arguments. The defense very much highlighted the state's burden in their arguments. It was very clear throughout this trial that this case had to be proven beyond a reasonable doubt.
So is it, oh, go ahead.
But I mean, going back to
Yeah, except for this issue we're talking about right now. Oh, wait, hold on. My sound just cut out again.
No, it's me. I was muted. I'm sorry. I was
Okay,
saying,
good.
I wanted to say, let me rewind, because all of them were jumping in at the same time. That was interesting to hear. And then also, while we're paused, you'd put in the chat that they pull up a visual later. Does it show the full instructions? Or
No,
the
it
relevant
shouldn't.
part?
It kind of shows like where they go back and forth.
Okay, so we'd be able to read it then, or if not, I have it pulled up in the brief, what they highlighted in the brief.
Okay, yeah, show that.
I think this would be good for grounding us here, you guys. So, the defendant has so specifically over timely objection, the court charged as follows. This is what the jury heard. The defendant has raised a defense that even if he committed the act described in the indictment, there are circumstances that justify, excuse, or mitigate it. Once this defense is raised, the state must disprove it beyond a reasonable doubt. The fact that a person's conduct is justified as a defense to prosecution for any crime based on that conduct. The defense of justification can be claimed when the person's conduct is justified under OCGA. Section 16-3-21, defense of self, or Section 23, defense of habitation. As used in OCGA Section 16-3-23, the term habitation means any dwelling. Now, personally, my brain's already annoyed that they say this first, but then jump to this.
Yeah.
I feel like you got to go in sequential of how you put it in the sentence preceding it. Sometimes a defendant's threat or use of force is legally justified, and so it is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when 1. He reasonably believes that the use of force is necessary, 2. To prevent death, and then there's an A death or serious bodily injury to himself or a third person, B. The commission of a forcible felony, which means a felony that involves the use of force or violence against another. Then it says aggravated assault is a felony which is defined above. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide that the defendant's actions were justified, then it would be your duty to find the defendant not guilty. A defendant is not justified in threatening or using force if he or she provokes a threat or use of force against himself, intending to use that threat or force as an excuse to harm the other person, or is the initial aggressor, unless he withdraws from the counter, I guess it should have said encounter, and clearly communicates to the other person his or her intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. Sometimes a defendant's threat or use of force is legally justified, and so is not a crime. A defendant is justified in threatening or using force against another when, and this is interesting because this is repeating a definition of like use of force justification. It doesn't really matter defense of others or habitation. Once he reasonably believes that the threat or use of force is necessary, or 1, 2, to prevent or stop the other person, 3, from making an unlawful entry into or attack on, 4, a residence. This is awkward. Doesn't that read awkward to you? Like
Yes,
this right here?
It should be numbered that way. Like I see what they're doing, but like just do bullet points.
But why is a residence its own thing? It has to.
I mean, like it's one of the elements. You have to prove that it's a residence that is being defended, or to
But
prevent.
wouldn't that just fit in line 3?
I mean, if it's like, I think it's a separate one because it could be like a restaurant or something. It wouldn't apply. But I mean, you could put it in line 3. I don't think it would make a difference. But I
Defendant
can
is
see. I can see.
justified when a residence. That's what I'm saying. That's how I'm reading it.
Oh, I see what you're saying. Wait, can you go back up a touch to the first part?
Yeah.
Oh, yeah, you're right. I agree. I see what you're saying.
When for a residence. So, and then we have this like thing that was spelled wrong. It was a wrong word, and this just seems messy. Oh boy.
I mean,
so it
I hate
continues.
it. It's just like formatting goes a long way when it comes to clarity.
Yeah.
This is
And
an
I mean, we'll
excellent
see the
example
visuals,
of
so we'll
that.
be able to see that it's formatted similarly to how it's represented here in this brief.
Yep.
Or do they just pull up the brief to show the visual?
They just kind of show like, you'll see. It doesn't really get into substance. It just kind of shows like section, like this section. I can't even explain it. You'll see. But it
It's
doesn't
weird
get into
because
substance.
I feel like even though we mention a residence here, it doesn't otherwise like counter, like it seems kind of repetitious of this, and it's not really distinguishing that we're talking about defensive habitation yet. It's just like repeating justifiable use of force in a slightly different way with different bullet points. So that, to me, I'm already thinking that's confusing. They say the state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide the defendant's actions were justified, then it would be your duty to find the defendant not guilty. A defendant is justified in using force against another that is intended or likely to cause death or serious bodily injury when 1. The other person is making or has made an unlawful and forcible entry into the residence. That sentence makes more sense to me than this one. 2. The defendant knows or has reason to believe the other person is making or has made an unlawful and forcible entry. And 3. The other person is not a member of the family or household. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide that defendant's actions were justified, then it would be your duty to find the defendant not guilty. For the defendant's threat or use of force to be justified, number 1, the defendant must believe that his threat or use of force is necessary. 2, that belief must be reasonable. That is, a reasonable person would also believe that the threat or use of force is necessary. And 3, the defendant's reasonable belief must be what prompts him to threaten or use force. A person who is not the aggressor is not required to retreat before being justified in use of force. In using force he reasonably believes to be necessary. The defendant's use of deadly force may be justified even when there has not been physical contact between anyone. If the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant's life is in imminent danger.
Yeah, now we're like self-defense.
Huh?
Now we're like back to self-defense. Or defense of self, really.
And I think that's confusing because what it's making me think is the person that's in the house has to be in a menacing presentation. So because this guy isn't the first one to jump up out of the bed and say, get out of my house, it's actually the homeowner that's like, what are you doing here? Who are you? I can see why that gets confusing if this is just a general defense of self criteria. It seems like it's applying to how you must react when trying to defend your habitation.
Yeah, it just is confusing. I mean, irrespective of what you think of the guy's guilt, it's kind of just muddled.
It's like loop-de-looped. If the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant's life is in imminent danger, the defendant is in imminent danger of serious bodily injury or forcible felony is about to be committed, then the defendant's use of deadly force may be justified. Words alone never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some menacing action may justify the use of deadly force. A forcible felony is a felony that involves the use of force or violence against another. Aggravated assault is a forcible felony, which is defined above. The defendant asserts, and it's so weird because you're charging him with the same thing that he's saying is a justification because he believed the alleged victim was about to commit against him.
Yep.
The defendant asserts that the victim's hands or fists were an offensive weapon. In deciding whether hands or fists is an offensive weapon, you may consider all of the following factors. The nature, and this is different formatting, the nature and extent of any injury inflicted, the character or capabilities of the weapon, the manner in which it is used, any display of it to the jury. What? To the jury?
I don't know, man. I don't know why like the manner isn't capitalized, but all of the others are, even though they're just semicolons and part of the same sentence. I don't know, man. I don't know what to tell you.
Any display of it to the jury. Well, he held his hand up, so he's guilty. Any other, in closing arguments, if Atkins was arguing, they'd be like, can we find him guilty? Any other circumstance in this case. A defendant is not justified in using excessive force while acting in self-defense. If you decide that the defendant used more force than was reasonably necessary to defend against the alleged victim's threat or use of force, then the defendant's actions would not be justified. This above quoted instruction is confusing. Okay, and then they go into the argument. So, yeah, I agree this was confusing. I don't know if they cite more.
Yeah, he said it well there. So they're impermissibly jumbled or confused or something. I agree. Like, it's confusing to follow, even. You can kind of pick it up.
Where do they mention the prima facie showing? Is it OCR'd? It better be.
It is on, it's on page 35. Yeah, you got it.
Okay.
I don't know if you want to read that whole thing. That's a lot.
Well, I want to see why it's stupid. Okay, so the trial court charged the elements of the crime of aggravated assault as follows. Well, no, I see why this is problematic. Because if you're telling them they only need to make a prima facie showing of the thing that would justify something else,
Yeah, it's like a predicate kind of.
So the trial court says for aggravated assault, the state must prove that appellant 1 assaulted another person and 2 with a deadly weapon or with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that appellant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. An offensive weapon is any object that is likely to cause these hands or actually does cause death or serious bodily injury if used against someone. A firearm, when used in a way a firearm is ordinarily used, is a deadly weapon. A person commits the offense of possession of a firearm during the commission of a crime when the person has on or within arm's reach.
It is 106, not 131.
Yeah, so maybe Steele said it wrong.
Yeah.
When the person has on or within arm's reach of his person a firearm during the commission of or any attempt to commit a felony, which is any crime against or involving the person of another. The offense of murder and aggravated assault are felonies under the laws of the state. When a defendant is charged with the violation of a law in an indictment where the crime may be committed in separate ways or methods, and said crime is charged as being committed in more than one way or method, the crime might be charged conjunctively, using the word and to list all ways or methods. However, the state is not required to prove all of such separate ways or methods alleged in the indictment. Rather, the state must make a prima facie case by proof of any one of the ways or methods. So this is why it's problematic, is this word right here, any one. This is the standard for any one.
Yeah, you have to prove the underlying felony beyond a reasonable doubt, not to a prima facie standard. That's crazy. I just don't understand how that mistake gets in there. It's so strange. This is a weird mistake to make.
I really think it must come from like a preliminary, like for us to get this passed and allow the state to continue the prosecution. Because those efforts must have been made, because we heard him Steele mentioned that one of the initial charges failed. It wasn't indicted properly.
I mean, the murder was acquitted in the first case. I know that.
Oh.
I don't know about the time though.
Interesting. All right, so let's get back to the confusion and the 5 questions being asked at once.
Very much highlighted the state's burden in their arguments. It was very clear throughout this trial that this case had to be proven beyond a reasonable doubt.
So is it? Go ahead.
But I mean, going back to the Devilbot case, I mean, the court there charged beyond a reasonable doubt as well, but we still reversed because the evidence made it unclear whether the jury correctly applied that given the closing argument.
Two things on that point. First, respectfully, that is true about the Double-Bot case, but also the argument that the prosecutor should never have made, that we've all learned now, was specifically in conjunction with the concept of reasonable doubt. They were talking about the state's burden when they said that it didn't have to be a particular number. That's not what we had here. This is a passing reference in one jury charge.
But would you agree that that reference should not be repeated in the future?
Oh, I do agree with that, yes. But just because it shouldn't be repeated doesn't mean that it invalidates this conviction.
Well, so there's a couple different, there's separate questions, right? There's, was it clear and obvious error? And then there's, did it change the outcome if in fact plain error applies? What is your best argument for it not being clear and obvious error? What role does prima facie case have for the jury's consideration, properly understood?
Properly understood, I don't believe it does have a role for the jury's consideration.
Which would make it clear and obvious error to include in a jury charge, right?
I would argue it doesn't because, again, it's in the context. But even assuming it is, that's one of 4 prongs to the plain error test. And when you turn to the...
Why would you argue that it doesn't? I mean, what good would it do for a jury to be considering whether the state had met a prima facie case of anything?
Well, the jury is going to have to consider whether the state established one of multiple ways of committing a crime. So in conjunction with that, that is something that they have to consider. And without any further definition, I don't know that that takes away from...
Is that what prima facie means?
By what standard do they have to believe the state has proved whichever method?
Beyond a reasonable doubt.
So
That's
prima
true for
facie has
everything.
nothing to do with that analysis, does it?
I agree. But then when you...
I feel like that justice just wants to write, like, prima facie has no business being in jury instructions in a criminal trial.
Yeah, I mean, it's just bizarre. Like, I don't know what to say. It's just a weird mistake, or I don't know how you want to say it. But also, like, the other thing is that the jury hung in the first trial, so clearly it's not
It's
like
harmful.
an overwhelming level of evidence. Yeah, I mean, it's almost. I mean, I don't want to draw more conclusions than I can from the difference between the cases, but clearly it's not an overwhelming evidence kind of case. If you have a mistrial or if you have a hung jury as to these very same counts, I don't know if that's part of the analysis. It's not part of the analysis, but just practically speaking, it seems like it's somewhat of a close case. Latin has no business in jury instructions. I agree. That's actually something that California does well. We use very little Latin at this point. Georgia, I think, uses a relatively large amount of Latin.
Didn't California, and I don't know like how the pragmatics would work, but didn't they put together like a multi-year program with scholars, practicing professionals, retired professionals to come up with like layman's language? Like a code book of how to simplify model instruction. That way they'd be available for judges, that the layperson on the jury could understand them.
Yeah, probably. There actually is a lot of like we have our like complaint forms are very like standardized and
you're one
effective.
of the best states that I've come across for just anytime it's a California case, I can look up the model instructions, civil or criminal. It might take me a minute to get to the right section, subsection area. But that's not something like New York is a nightmare to try to find.
Ooh, that's true. Motions in limine, that is still a thing I hear in California. That's fair.
Motions in limine. That's how do you guys say it?
Limine.
Ew. That sounds like a Pokemon or like a spell in an RPG.
You're a spell in an RPG.
No, I'm not. It's okay. I'm hitting the play button.
Look, I submit to the court that clear and obvious error means something that goes against what our courts have said and what the case law says. This language is drawn from case law. Is it ideal language? No. Should it have found its way into the instruction? Probably not. But that's why, and I'm not going to die on the hill of whether this was clear and obvious error, because the bigger question is whether or not it had any effect on the outcome of the trial. And as the court has pointed out already, in this case, there was no question about how the aggravated assault took place. As a matter of fact, there was very little factual dispute about anything in this trial. Mr. Medina testified that he did shoot James Thornton and that he did so in that room on that day with his own gun. The only question was whether he was justified in doing so. So even if the aggravated assault count was described as either putting someone in reasonable fear or actually causing harm with his deadly weapon, there's no question about what happened in this case. That was embraced by all parties throughout the entire thing. So I don't know that this was a question, even though it theoretically is something that the jury would have considered, I don't believe there's any reason why they would have gotten hung up on this question, given how clear the evidence was regarding those counts.
But you would admit, I mean, again, based on his own account, that there was a prima facie case of both.
Yes, because
But that doesn't matter in any way to the jury's assessment of guilt. And so if the court has told the jury, the state has to demonstrate that there's one or the other or both, they've made the prima facie case. Anybody who does know what prima facie means would say, well, they obviously have done with respect to both. But that doesn't mean that they're guilty.
That's true, but I also don't think that it's the end of the question, because even if the state establishes something to a prima facie degree of which way the offense was committed, the jury still has to believe beyond a reasonable doubt that the...
Sorry, chat, we should explain. So prima facie showing is like, if you, whatever's being argued, whatever's being alleged, if you take that at face value, is it enough to demonstrate that thing that you're saying these facts would support as an argument? So anyone that didn't know, like, prima facie, it's the takeaway here is it's a very low position on the standard scale. Reasonable doubt is like all the way at the top.
Yeah, it's
like
prima
facie would be like all the way down here.
Yeah, it was like very preliminary, just initial glance, first impression. Yeah.
Defendant actually committed that offense intentionally, and that's where it stops being clear and obvious error. But this is, again, one of the things that highlights why the court needs to step back, and that's also true for the other enumerations.
So before we move on to those, one more question on this. The argument that because prima facie case wasn't defined, the jury wouldn't have known what it meant. We generally indulge a presumption that the jury follows all instructions. Why would we single out one instruction to presume they don't know what it means? I mean, isn't that inconsistent with the presumption we typically engage in?
If I gave you the impression that that was my argument, I apologize, because it really isn't.
Okay.
What I'm trying to say is that, as this court also knows, everything that the jury considers, they have to consider in context. And when you look at the location and the surrounding words and the context in which that charge was given, it is pretty limited to the one thing they have to decide.
Yeah, you're saying in context, they essentially ignored it.
Possibly, we don't know if they did or not.
Sure.
Exactly.
That's not a
There
good
you
fact
go.
for you, but yes, I mean, I do understand your sort of macro. If you look at all the
Yeah,
instructions.
let's run her back. Let's run her back.
Great.
The location and the surrounding words and the context in which that charge was given, it is pretty limited to the one thing they have to decide.
Yeah, you're saying in context, they essentially ignored it.
Possibly, we don't know if they did or not.
Sure. I mean, that's not a good fact for you, but yes, I mean, I do understand your sort of macro. If you look at all the instructions, that fell to the wayside somehow. Whether that's right, I'm not sure, but I'm picking up what you're putting down.
Okay, I appreciate that.
You wanted to move on to your other enumerations.
Yes. So I think that it's important, because it really affects both of the remaining enumerations, to look at this case from the lens of what defenses actually applied. The arguments here are that the court made correct, but perhaps badly ordered charges about the affirmative defenses. And before we even get into whether that could have been improved or whether it's so bad that it affected the outcome of the trial, I think that we need to assess whether there was any harm flowing from this at all. Because in this case, even though the parties were hyper-focused on whether this abandoned house was a residence for purposes of defensive habitation, they basically glossed over the fact that for defensive habitation to apply, there has to be an ongoing attack or entry into the home. And without belaboring the facts, I know the court knows the record, the evidence shows that the victim, Mr. Thornton, was already inside the home, probably asleep, when Mr. Medina came in and encountered him there. It's almost the reverse of what you typically see in a defensive habitation case, where someone inside the home is acting to
So you can't defend once somebody's already inside? Is that your position?
No, not in every case, but I think you have to look at this as from a factual basis. Like, was there an ongoing attack on the home? Was there
If you
an
wake up in the
ongoing
middle of
entry?
the night and someone's in your house,
Well, that is a classic defensive habitation, but you're already inside your house and
So
you
if I
wake up to find
return,
someone.
if I've left my house to run some errands and I return to my house and I see someone inside it and it was supposed to be empty,
And they're naked in the
I
bed.
don't have defensive habitation available at that point?
Under the current case law, I'd argue that you don't. If you look at some of the cases this court has decided, they have found that defensive.
Kat, remember what state we're in. This is Georgia. I don't think this is
Yeah.
a great argument to be making in the state of Georgia.
Even the lawyers have guns, all of them.
Like,
Every
I mean,
issue with gun at birth. Like, I don't have a gun, but like, everyone's got a gun in Georgia.
I'm not sure this is a great argument to make in any state, let me be clear, but I'm saying, especially.
Yeah, like it's such a weird distinction to draw too. Like once they're inside your house, oh, if they can get inside your house, you're you're screwed. They're just gonna kill you. You're dead now. But if you can keep them outside the house, you're fine. It's just such a bizarre like argument to even go for. Again, especially in Georgia.
Like, think of the scenarios for like domestic issues, like domestic violence, like bad relationships,
Yeah.
where I don't know. This is just not the argument that I think would be a great one to land on.
Yeah, I think this is actually hurting.
Oh.
Can you go back like 15 seconds? I want to hear that again. And
Yeah.
I think that this is like not just not working. I think it's actively hurting.
Oh, his poor face. That is an unfortunate. He's like, oops.
Classic defensive habitation, but you're already inside your house and
So
you
if I
wake up to find
return,
someone.
if I've left my house to run some errands and I return to my house and I see someone inside it and it was supposed to be empty, I don't have defensive habitation available at that point?
Under the current case law, I'd argue that you don't. If you look at some of the cases this court has decided, they have found that defensive habitation applied to somebody that was inside a car, which of course a car is a habitation for purposes of this rule, but it didn't apply to somebody who was out.
That's actually interesting he says that, because that's not entirely the case. You can't shoot somebody for breaking into your car unless you're actively in it, right? Isn't that maybe?
So.
So I don't think that's a parallel argument. Also, I think this is such a good point here. From Creation, Life, Opportunity, Destiny says, so retreat has less merit for defending yourself. Get out of here. The idea that you suddenly have a duty to retreat and don't have the right to stand your ground when you enter your own habitat, your own residence, is kind of the argument. This argument is going, the pathway this argument's going down. You have less of a right to stand your ground in your own home. So I think that was a good one there. Yeah, I'm in Florida, guys, by the way. I'm in Florida.
Outside of the car when something was going on.
Counsel, let me make this point. I mean, this defensive habitation is under subsection 2, which there are 3 subsections related to when deadly force can be used. Subsection 2 was actually added in 2001, and I believe the cases that you've cited, Nesbitt and the other cases, involved 1 and 3, which you do have to have some sort of ongoing entry or attack, but I don't see that as a requirement in subsection 2.
So
if someone comes into your home, that situation, that's what that covers.
So let's step back for a moment, because I think that the defensive habitation charge, and this gets more into the second enumeration, but I think that the defensive habitation charge is really a 2-step process. As the court pointed out, there is the first step of determining whether someone felt that it was reasonably necessary to defend, to prevent or terminate an entry or attack upon home. Inherent in that is the idea that it is happening and you are trying to stop it. I don't think that it necessarily applies when the entry has already happened and there is absolutely nothing going on except for someone sleeping in bed.
That would explain prevent.
Yes.
But not terminate.
But terminate.
There's 2 words. I mean, so is your argument that once somebody's cleared the threshold or the windowsill or what, you no longer are defending the habitation? I mean, in other words, I think the terminate has to do work, and it has to suggest something beyond just the moment of entry, right?
Yes, but that could be as simple as prevention is while someone is still outside the house trying to get in, and terminate is while they're in the middle of entering.
No, but the prevent, then you're going to get yourself in
Again,
a-
so once they've secured entry, you say terminates while they're in the middle of entering. So again, when they've cleared the threshold, the state's position is once you've cleared the threshold and the windowsill, once you're in, then then defensive habitation is no longer applicable.
In the situation, no, because that presumes, again, that someone is entering into the home. Again, conceptually, defensive habitation is codifying the castle doctrine, that someone has the right to defend themselves in their home. Inherent in that is the idea that they are in their home. A, that they are in it, and B, that it is their home. We didn't have either of those things in this case.
Well,
Wouldn't it be interesting to see? Oh, I wouldn't wish like a different death on anybody, but just hypothetically here, to see a trial where the squatter shot and killed the homeowner.
Yeah, I mean, it seems like he actually could have, if it had gone the other way, I think that might have been an available defense.
So
They are in it, and B, that it is their home. We didn't have either of those things in this case.
well, he was in
True,
it.
Aaron.
The victim was in it.
Well, and so was the defendant at the time that the shooting happened.
After he had entered in, yes.
So your
But-
scenario is that a person would never have the right to protect their home if they weren't in the home first before a person entered.
The case law would seem to suggest that, but that is also where
Well,
this
we get
dovetails-
things wrong sometimes.
and we like
And maybe
opportunities
this
to
is an
fix
opportunity
them.
to clarify, but that is also where defensive habitation dovetails with self-defense. Because you have to remember that those two go hand in hand. And in this case, once someone is inside the home, it potentially morphs into a self-defense argument if there is a reason why the person has to defend themselves.
So the
It can be
castle
both.
doctrine only
it
allows
dovetails.
me to stand at the gate and keep people on the other side of the moat. Once the barbarians have entered the home, it's no longer my castle?
Well, it depends on who is and obviously as the owner, you have the right, but if you'll indulge me, it depends on who is invading and who is already inside. Your situation, you absolutely.
Is that
would have
how,
the right-
do you think that's how people understood that, like from the founding?
That's a very good question.
It seems awfully parsed.
Well, it is, but so many things about the affirmative defenses are. I think that the bigger issue is that in this case, even assuming that I am wrong, and even assuming that defensive habitation did apply, there's nothing about the way that the court gave the jury charges that would have misled the jury about anything. The main point that the appellant is making in this case is that it allowed the jury to import ideas like the doctrine of reasonable beliefs from self-defense into defensive habitation. But step one of that concept for either self-defense or defensive habitation involves the doctrine of reasonable beliefs. So when you look at the order of the court's charges, and again, this is in the brief, but it may be helpful to have in front of everyone,
Is this a visual?
the court gave an unusual order of charges. It began with a
Here it is.
couple of
This is what I'm
charges
talking
that
about.
really applied to both of them. And then as you can see from the colors in that image, it basically alternated between defensive habitation and
The
self-defense.
color choices make it look like a
You know,
gang war.
if I were in the trial court shoes, would I have given this way? Perhaps not in hindsight. But that doesn't necessarily mean that any of these charges were wrong or that they actually caused the jury to blend those concepts. Particularly
You know what the problem with this is, though? I mean, this is not what the jury had in front of them. Like, the jury didn't have nice block formatting, blocking
Yeah,
things over
yeah.
and spelling it out. So to even bring this up, I don't even... You're showing that you need to clarify what the instructions meant because they're confusing.
trial court shoes, would I have given this way? Perhaps not in hindsight. But that doesn't necessarily mean that any of these charges were wrong or that they actually caused the jury to blend those concepts, particularly when you look at the actual language of the charge. I know that excessive force came up during the discussion earlier. When you look at the way that the court delivered the excessive force charge, it specifically says while the defendant was acting in self-defense. That is explicitly in that charge. Several of the other charges that apply only to self-defense, no duty to retreat, threats justifying a homicide, very clearly are about self-defense, not necessarily defensive habitation. So it is an uphill battle to say that the jury was not able to parse this for themselves, particularly when, although the court may have been able to use headings or say, I'm moving to a different defense now, or do something along those lines, even the introduction to the defensive habitation charges made it pretty clear that it was transitioning to a different topic. So when you actually look at what the alleged harm is in this case, it just isn't apparent from the charges that were given. Were they ideal? No. But were they wrong? Also no.
I was very
That
confused with
also
where they were.
goes to the final topic, which is whether
It was just sloppy instructions.
Mr. Thomas, trial counsel, performed deficiently in not objecting when this state argued that this house was not a residence. And this does highlight an area where there is not a lot of clarity in the law. The terms habitation and dwelling and residence were used in place of each other all throughout the trial and all throughout the decisional law and all throughout the statutes. But the core idea when you're looking at the ineffective assistance claim is simply looking at whether an objection along those lines would have been successful. And as the Attorney General has pointed out, and as the state also agrees, this was clearly a contested fact. This was something that the parties argued about both in front of and outside the presence of the jury throughout the case. And a prosecutor has latitude in closing argument to address those contested facts. The defense also has the ability to address those, and both did. The state argued that this was not a residence. The defense gave several reasons why it was a residence. So just from a factual standpoint and from a trial strategy standpoint, that objection likely would not have succeeded. Because
So let's say that I buy a house.
Wait, Jim, can you, so, because we're dealing with the second enumeration of error, or I forget which number it was, but the ineffective assistance of counsel, and it's an ineffective assistance of counsel on the basis that the trial attorney, so the defendant's trial attorney, didn't object while the state was saying the location is a dwelling or not.
Yeah, that's right. I'm looking at it now. I haven't really looked at this one very carefully. Preserved. Yeah, I don't really see. Yeah, I don't really get this one. I'm looking at it now.
Well, it's this part, this sentence.
Yeah.
So that's, were they saying it wasn't a house, or were they saying it wasn't a dwelling because it's the guy was just in the bed and what, like?
Yeah, I think they were saying that because he didn't, the shooter, man, it's too bright in here. The shooter did not live in that house at the time. He was preparing it to be lived in by family, but he didn't live there at the time of the shooting. So that's
they're saying it's not his dwelling.
Yeah, it wasn't his residence. I think this guy on screen here said it's not where he rested his head at night or something to that effect.
Okay.
But you know.
And that argument is just ineffective assistance of counsel for not objecting in the moment.
Yeah.
Got it.
And I haven't moved in yet. I'm still in my old house, but I visit the new house to, start working on move-in plans. If someone attempts violently to enter the house while I am in it, defensive habitation doesn't apply to that?
no, it would apply, particularly because, as you said, the person was attempting a violent entry, because that's another aspect.
Well, but no,
Yeah,
the question is more about, does that count as a habitation, as a residence?
Okay, here we go.
When you look at the concepts of what a residence is, all of the definitions, nothing is explicit, but they all seem to indicate it's the place where you rest your head at night, is the place where you live on a daily basis.
So the decedent here was certainly treating it as a habitation.
Presumably,
The evidence is clear. This person was found sleeping in the house in a bedroom, yes?
He was. I don't know if there was proof that he was there more than one night, but he was definitely there on the morning of.
You have to be there more than one night for it
No,
to be a
no.
habitation? Okay.
I'm just making sure we're clear. I'm not disagreeing with you.
But for the defendant, he was there to prepare this to be a residence, correct?
Sometime
There is evidence to support that.
sometime in the future, yes.
Right.
I don't know that he's
Like my house that I have purchased, but I have not yet moved into, and I am there
Oh,
working to make it ready.
Yeah, I was just skimming
I
through the
don't
brief.
know
It
that
looked
it would
like
count as a residence at that point.
the defendant had gotten the utilities activated, which to me seems like a pretty strong indication that he was fixing up the house. You don't turn on the utilities. You're not planning to live there.
well, not for nothing, but you've got one of the justices picturing themselves. That statement from the justice is like, the house that I'm preparing to move into. So you have a justice imagining themselves walking into the house they just purchased, ready to move into, maybe ready to move their family members into, and imagining running into this scenario.
Yeah. And again, I don't think anyone's trying to say that, nobody's happy this happened, but nobody wants to kill anybody, but at the same time, we're talking about life in prison for being surprised at somebody in a home that you own in the middle, first thing in the morning.
Whew. Let me run it back like 10 seconds.
Like my house that I have purchased, but I have not yet moved into, and I am there
That Chief Justice money hits different.
working to make it ready.
I don't know that it would count as a residence at that point because you are simply working to make it ready. Now, there is a version of defensive property that applies to things that are not residences, and there's a reason why they have that separate thing. I understand that I'm out of time, but please keep that in mind. Thank you very much.
Thank you very much. Mr. Steele, I believe you have just over a minute left.
Defensive habitation was a key piece to the defense, and that's all in the testimony of appellant, volume 13, page 493 through 534, specifically asked, did you board the home? Yes. Why? Because we did not want any more forced entry. Did you lock the doors? Yes. Why? Because we did not want any more forced entry. Did you sleep there? Yes, I would take naps there, and I was getting it ready, and I would sleep there on occasion. It was the...
So there's trial testimony that the defendant would rest their head there. So that's interesting. That's really not good for like an either or.
House that I consider my home since I've been a child. Defensive habitation is not some thought of after the fact, so it doesn't matter that the charge is corrupted. In addition to that, I see no guardrails. It is too perfect for this honorable court when you read it to a jury to say, oh yeah, this applies only as self-defense and this applies only defensive habitation. It got mixed together, and the restrictions that are not on defensive habitation were put upon it in the appellant's case. I will answer any questions. Otherwise, I want to thank this honorable court.
Thank you, counsel, for both sides. Well argued. We'll get you a decision within the time required by the Constitution. Thank you.
All right, so the next one. Any thoughts, Jim, on the
I can't
Medina
even
case?
remember now.
The next one is Larkins.
Yeah, I mean, I think it's at the very least, I think a new trial is warranted, just based on how muddled the jury instructions were.
I mean, we needed a whole visual to say it was structured this way.
Yeah, I mean, it was just messy and incoherent, and it was just like lazy. It wasn't even like it wasn't complicated because it was a complex question of law. It was just confusing because it was sloppy. The 1, 2, 3, 4, no bullet points. It was all like one chunk of text. It was just poorly structured. It wasn't well put together. And if somebody's life's on the line, I think you should, be competent.
You didn't know they have searchy transcripts.
Oh yeah, I didn't know that either.
Because I don't know if they use like Vimeo or what hosting they use, but
yeah, it's Vimeo.
They do have the option.
You know what my favorite part about this one is?
Pinson
never mind.
talks.
It's that Brian Steele introduces himself, even though he had literally just spoken 30 seconds prior to introducing himself. He's been there the whole time. I just find that hilarious.
Well, I mean, it's probably not every day you have to argue in front of the Supreme Court of Georgia or any state twice in a row.
He's got another one coming up in a couple of weeks, or maybe a month. In the next, him and Andrew have that case with the what's her face, the one who tried to do the citizen's arrest.
Oh yeah. I always forget her name. Payne?
Yeah, I don't really follow
something
it, but I think Hannah maybe?
Yeah, I think it's something like that. It's a shift. I think it's like one of those 3 names. Where there's like, you say the whole, like the 3 names.
You say the whole thing.
You say the whole thing. Yeah, he's got to keep the record clear.
Yeah. Yeah, always down. I look through a lot of cases to try to find, skim through a lot of oral arguments to try to find stuff.
All right, I'm going to read this brief real quick before we play this one. Larkins v. the State. Matthew Larkins is appealing his 2019 convictions for malice murder and other related crimes stemming from the shooting death of a woman as she drove a coworker home following an overnight shift. Larkins was sentenced in Fulton County Superior Court to serve life plus 25 years in prison. On appeal, Larkins argues, this is the, Brian Steele's side, argues that the evidence presented at trial was insufficient, a sufficiency argument, to support his convictions because the prosecution failed to adequately corroborate the testimony of an alleged accomplice, that the trial court committed plain error when it gave a misleading, erroneous jury instruction on the use of a co-defendant's out-of-court statements and trial testimony, that the trial court improperly commented on the evidence presented at trial, that trial counsel's failure to object to those improper comments equates to ineffective assistance, and that the trial court erred when it admitted hearsay statements under the co-conspirator exception. Larkins further challenges Georgia case law. This is Brian ready. He probably was like, yes, I will argue this case. Larkins further challenges Georgia case law, allowing prosecutors to give non-substantive initial closing arguments. Oh.
No, actually, one thing you reminded me. Let me see. The sentence. Okay, on appeal, Larkins argues that the evidence presented at trial was insufficient to support his convictions because the prosecution failed to adequately corroborate the testimony of an accomplice. So that's actually a specific statute in Georgia.
I think some other states have it too. I think Tennessee has something similar where it's sufficiency of the evidence is kind of like, well, if they can present it, then it becomes a fact-finding issue for the trier of fact, usually the jury or judge in a bench trial. But I think in Tennessee, and what you're going to get at is it's something specific relating to the statement of a co-conspirator. There needs to be a little bit more meat on the bones.
Yes. It's basically right. So you can't, and Steele's gotten a murder conviction overturned on this before. Somebody in Fulton County, actually. Basically, you can't convict somebody only on the testimony of a co-conspirator. That makes sense because, all you have are, say you have two people who were involved in a conspiracy and all the evidence is one person testifying against the other one. It's kind of inherently unreliable. So you need to corroborate the co-conspirator testimony. The other one that you'll hear is circumstantial evidence. If the case is entirely circumstantial, you need to rule out all other possibilities. So those are the two statutes that you'll see referenced.
Very cool.
The circumstantial one, I think I told you, or I did a video on the case. I think it was also Fulton, but the case that is now before it was definitely Fulton. It's before the U.S. Supreme Court now, where there was a woman in a hotel room and her whole family was in the hotel, and it's not clear whether she conspired with her son to commit the crime or if she just lied after the fact to keep her son out of trouble. It was an entirely circumstantial case, and it just wasn't clear whether she was involved only after the fact or involved in a conspiracy.
Well, what I think is interesting is with this, these issues seem intertwined, right? So I'm surprised we don't have a specific, and I don't know if they would list a cumulative error in the summary here, but I feel like if I open the brief, there might be a cumulative error raised. But this first issue, they failed to adequately corroborate the testimony of the alleged accomplice, and then also that the trial court erred when it gave a misleading, erroneous jury instruction to the use of a co-defendant, who I'm assuming is also the same alleged accomplice, out-of-court statements and trial testimony. So it kind of seems like we might have a cumulative effect here. We'll see what Brian's. Oh, the state. Let me tell you the state's position, chat. Hold on. Not just going to skip the state. The state, represented in this case by the Atlanta Judicial Circuit's District Attorney's Office and the Office of the Attorney General of Georgia, argues that the evidence presented at trial was sufficient to support Larkins' convictions because there was sufficient corroboration of the accomplice's testimony. The trial court did not plainly err in its instruction to. They're going to say they didn't do these things. This isn't really adding anything new. Let's see. And then, right? It's all the same thing. They're properly admitted. It's just the reverse of what we just read. So.
Yep.
There we go.
Yep.
So
this one's argued by Ruth.
By who?
Ruth Pollack.
Okay, so Ruth Pollack. All right, start the clock.
Brian Steele for appellant, Ruth Pollack for appellee.
Mr. Steele?
Wait, hold on. I have the perfect clip for this occasion of a double steal.
Oh, help me. All right, let's not comment on the various attorneys.
Hello.
If you guys might remember, Miss Latner's was called repeatedly during the YSL trial to introduce CAD reports, 911 calls. And when they told her that Brian Steele had questions for her, it was like, here we go again. It's Brian Steele back up at the lectern. So
You're back to back.
May it please this honorable court, I'm Brian Steele, and I have the honor, along with counsel, to represent appellant. Appellant was indicted for criminal street gang activity that ended up being no pros. So it's malice murder, felony murder, aggravated assault, criminal damage to property, possession of firearm by a convicted felon, possession of firearm during the commission of a crime. Appellant, the other felony murder was also no pros, dealing with the gang count. It was severed, bifurcated, and then no pros. Appellant is currently serving life in prison plus 25 years. The jury returned a verdict of guilty on all of the counts. The facts are tragic, but unfortunately simple. Appellant's having a activity, an event at his home. A person gets shot in his home. There is then a hunt to find that person responsible or those persons responsible. According to one of the co-indictees, co-defendants, who cooperated with the prosecution and received the voluntary manslaughter probation offer and acceptance and sentence. Appellant and four other people went in two different cars to find the people who did the deed to their dear friend and put their friend in the hospital from shooting. The dear friend, earlier in the evening, a woman just driving home from work early in the morning hours. She drops off a colleague, and her car gets riddled with bullets. She goes off a embankment. The car flips. The
She might
wheels are
influence
turning,
the
and
spreading.
she's shot in the face, in the head, and she dies. A person dropped their cell phone at the scene of the crime.
this is
And
this is the bingo card, isn't it? We're getting all of the things. There's a cell phone. There's riddled. What else are we gonna get? We did have that today, but in a different trial.
Did a great job. They looked at that cell phone. They had search warrants. They downloaded it, and then they looked at who was speaking to whom at about the time of the killing, and then they traced it back and eventually arrested the persons who were charged. 3 people go to trial. 1 person testifies. He is acquitted. The other 2, my appellant and the co-indictee, are convicted and sentenced the way I said to honorable court. We have raised 4 issues. We'll discuss any and all with this honorable court. If you don't mind, I'd like to start, and I'll go anywhere you want, but the evidence against appellant was weak. So Mr. Fuller is the accomplice. So as this court taught us under 24-14-8, his testimony must be corroborated. Jury instruction, federal court, similar. You have to really scan with great care when somebody's an accomplice giving testimony. Here we have to corroborate it in some independent manner. And the independent corroboration is mostly cell phone records. So law enforcement get appellants' cell phone records, or who they purport to be appellant's cell phone records. They move them into evidence with the identifying information. It did not lay a proper foundation. The trial court sustained. The trial lawyer, it's a great trial lawyer, the Honorable Bruce Harvey, represented appellant, sustained
Surprised he didn't light the
objection.
room on
So
fire.
the action.
Wait, what?
Bruce Harvey. I'm surprised he didn't light the room on fire.
Yeah.
Actual documentation identifying whose cell
I'm getting
phone
my
it is
copy.
did not go into evidence. But there was testimony from the co-defendant who testified at trial, who was acquitted, that in his phone is the same number, and it comes up with a contact, Quick or Quicksand, and that is appellant's nickname. It's appellant's social media
Nice
platform.
nickname.
So there was
Quicksand.
evidence to say potentially that these records belong to Quicksand, the numbers match up, and then that's appellant. The records then show, for purposes of cell site location data, that these records travel with the other persons, including Mr. Fuller, at and around the time where the killing is going to occur and afterwards. So it's incriminating evidence. The cell phone records are good for the prosecution, and if this court, we raised it as a sufficiency also, if the Honorable Court believes that that's sufficient to corroborate the testifying accomplice, then that's our corroboration. But the issue is, appellant's lawyer said, I'm not conceding that's our client's cell phone. I am not conceding that's my client's cell phone. So in a world most adverse to appellant, in closing argument, his trial counsel stated, at most, if you first believe that these records belong to my client, at most they just put a general area, doesn't put the client at the specific location. So the issue was, first, are those records belonging to the client? The jurors are deliberating. The jurors ask for all cell phone records. The trial judge then, and I quote.
So we heard with the first case that we listened to, the inquiry from the justices, well, were there any jury questions? And the reason that's important is if the jury, if you can discern, if you have reason to believe the jurors were inquisitive about a certain area or legal definition or how they were instructed, it's easier for the justices to make the inference that whatever the issue was, if they agree it's an issue, then it can also pass the second test, that it was harmful. So, so we've got a question. We've got a question.
It doesn't put the client at the specific location. So the issue was, first, are those records belonging to the client? The jurors are deliberating.
Aaron,
the jurors ask for
accurate.
all cell phone records. The trial judge then, and I quote, this is a quote, this is at volume 9, 1498, lines 9 through 14. This is the trial court speaking to the deliberating jurors. You still have requested phone records, and the court's interpretation of the note was that you wanted phone records, also the phone records, and then a juror cut off or interrupted the trial court and said, for those 3 days. And then the trial court, and here's our issue, for all of the defendants. And the juror then says, if that's possible, yes. And when I read that on appeal, I believe that the trial court, on a contested issue, I disagree respectfully with the Honorable District Attorney's Office that this was not a contested issue. This was a contested issue.
Did he twitch when saying that?
He thought about it.
I believe that the trial court, on a contested issue, I disagree respectfully
Right here.
with the Honorable District Attorney's Office that this was not a contested issue. This
I
was
will
a
say that
contested
there
issue,
are
and the trial
attorneys in Georgia who refuse to practice against the Fulton County District Attorney's Office just because they know that it's not a fair fight. They just refuse to do it.
Well, and then there's all of the issues of like, you don't seem to have an opportunity for any pretrial litigation negotiations, ways to streamline things. It seems like Fulton County is only amenable to that type of thing when there can be a global resolution with multiple outstanding cases, which is a product that they create on their own, right? You put someone in Rice Street, holding them on something, then you give them another charge because of something that happens in the jail, and now you have extra leverage because you can go to the counsel for that defendant in numerous cases and say, look, you've got all of these things, let's just resolve all of them. It creates leverage for the state.
Yeah, I mean, Rice Street's part of their trial strategy.
It's part of their DA dispatch newsletter, Law Corners. So
I was going to say it, but yeah. Yeah, I mean, there's a YSL. Aaron, I think, mentioned this first. There's a YSL. We were actually just talking about this the other day. Like YSL label person. Hello. Who said hello? I didn't read the
Chelsea.
Okay, Chelsea. But yeah, there's a YSL like label signee who's been waiting for a trial on a murder count for like 2+ years now, and just got kicked down the road like another 5 months. He's been in jail for like 2+ years now.
Can't take him to trial until you pick up a violation while in jail.
Yeah, and I mean, I'm sure I'm sure that he, they're listening to all the jail calls, hoping that he says something. It's just part of like Rice Street works exactly the way that they want it to work. It's not like people are like, you need to fix Rice Street. It's like, no, it's not. It's not broken. It's just it's not broken to the people making the decisions. It's the way that they want it to be. It's supposed to be terrible. That way they can leverage it.
Not
I think
Right
it's broken.
Street. Adventure Aaron said Right Street. Oh, that's how the state views it. So yes, the issue of being able to listen to those jail calls, and then the secondary issue of being able to search a cell, where it's a way to get around.
Yeah.
If someone in there has their case materials or anything that they're writing to take notes about how they plan to defend their case, because they're not supposed to just have 24/7 access to communicate and prepare their defense. There was a law corner in Fulton County District Attorney's Office DA dispatch about how you can use jail cells.
Yeah.
Some fight breaks out, now you can search whatever's in the cell. So,
Yep. Yeah.
very interesting newsletter.
Yeah. One thing I'll say is like, okay, this is like a dirty little secret that's not even really a secret, is at this point, everybody in jail and even prison has a cell phone. Sometimes better cell phones than I have, which I think is kind of messed up, but I'm not talking about anybody, any particular defendants. But like that's just how people pass their time now. It's like an open secret that jail and prison administration lets you have a cell phone because of people are just like spending their time, serving their time by scrolling through Instagram and Twitter and YouTube. They're not writing. And so to a large extent, like educational programs and rehabilitative programs have just been replaced by letting inmates have cell phones.
I wish it wasn't a replacement, but I think both should be on the table unless there's a reason otherwise. But it sucks I didn't realize there was a give you this and take away that. I thought it was just an additional. That kind of sucks.
Yeah. Like dudes have like PlayStation 5s in prison now. Like they'll have like whole gaming setups in prison. But my point with that was that like somebody acting normally and within the real rules of prison or jail is still going to be technically violating the law. Like all of those, everybody who has a cell phone in jail or prison is violating Georgia law. So they can get you on they can get pretty much anybody in time they want on a felony. It's not hard. And it's just like it's just the way it is. I mean, they want people to have cell phones, but they can turn around, flip it anytime they want to.
I pulled this up as a random example. This issue's just hearsay informing expert testimony, but this is and they're using like the Law and Order for the law here. Like, how it has that like glowing text for Law and Order.
Oh yeah, I didn't notice that.
Yeah, the graphics team is on it. The G unit, as they call themselves. But this is in, I think, most of the issues. I don't know if they're in like the beginning issues if they were doing it. They've got these little blurbs, like a page long, where it's like, hey, here's an issue that prosecutors run into that they have to overcome at trial. And here's our tips for doing so while coloring within the lines, without coloring outside the lines. And I think they've been really insightful to look at. If you guys ever want to go take a look at that.
I almost cited to one.
You said what?
Actually did cite to one, but then somebody made me take it out.
According to Gautam Rao or whoever wrote the one. But this is the link. You can just search on Google if you want to find it later. But in the chat, there's also a link. Just do Fulton County DA Dispatch and it'll take you to the newsletters. And you can just go through and start seeing some like what they're doing, and then scroll until you find the law corner pages.
Yeah, I think
cover like their recent convictions.
I think Kevin did the first batch, and then my guy here took over.
How to deal with unresponsive witnesses. So coaching on how to deal with an unresponsive witness. All that stuff.
You just lock them up until they say what you want.
And unfortunately, they stopped doing them in March of last year, which I feel like is our fault.
I hope so.
Badge of honor.
There's some stuff in there that they really should not have said.
No, I agree.
There was some serious self-snitching going on there. I don't think they realized, like, that's the thing with Fulton County is we need to get back to the oral argument, but they self-snitch constantly. Like, I don't think that a lot of the team realizes what you're not supposed to do. And so they'll just admit stuff that they shouldn't, and they don't seem to realize, no comment. Like, even in the cases, I'm not going to talk about specific cases, but cases I have, when you get to appeal, they'll just admit stuff that happened at the trial court level that they shouldn't have done, and they don't even seem to be aware of that. I can answer that. No, there's no update on that one. We're still waiting. I think we're about a month away based on what cases are being decided right now. It could be sooner. I hope it's sooner, but it is. I mean, we have like 9 enumerations of errors, so it could be a long opinion to write. You guys may remember Gautam Rao from what was that case he lost in hilarious fashion recently?
Oh, the one with the expert witness decision. I can't remember his name.
Yeah,
So
they were trying to get
they wanted the juror from the first trial to be an expert witness in the second trial in front of Judge McBurney. I don't know. If I look at my YouTube feed, I'll see it. I'll see the name. But yeah, hilarious, Stevie.
Exactly.
That is where that originated.
That's right.
Also, shout out to Take It to Trial in the chat. Good to see you. I'm sure you've had a long day. Take It to Trial covers like a million trials at a time as well. So
wait, why isn't Erin coming on the show? She knows more about the stuff than I do.
Yeah, Erin, you can always come up. Let me know. I'll start sending you StreamYard links. I'll send you links, but I won't tell Jim, and you can just like pop on unexpectedly and say thanks to Jim. That'd be fun. Oral arguments, guys. Oral arguments, guys.
Okay.
This guy's sitting here patiently waiting for us to resume.
I was kind of hoping there'd be a face in the background.
Who in authority?
Oh, let's run it back, so that way contextualize where we were.
All of the defendants.
I can explain this part
if that's possible.
Yeah, so basically what he's going to say is the jury asked for the phone records. The judge and the jury are going to clarify that what they want are the defendant's phone records. The judge then gives all of the phone records, including who the judge thinks, including the phone records that the judge thinks belongs to the defendant. But that's a contested fact, whether these specific phone records are in fact the defendant's phone records. So by responding to a request for the defendant's phone records, by giving the phone records, it's essentially saying, I think that these phone records belong to the defendant. If that makes sense?
Well,
that's what
still,
he does.
Yes. And when I read that on appeal, I believe that the trial court on a contested issue, I disagree respectfully with the Honorable District Attorney's Office that this was not a contested issue. This was a contested issue. And the trial court is the person who, in authority, who told the deliberating jurors for all of the defendants, there are 4 records. That puts appellant right in the middle of what he's arguing, that those are not my records. The state hasn't laid the foundation. That if that cell phone doesn't belong to me, there's 0 evidence but the accomplice, and the accomplice has to be corroborated. That is the first issue. So there's no objection to it. So I had to raise it under the rubric of deficient performance and prejudice, and that's my prejudice and that's my deficient performance. If you have no questions, I was going to go on to another topic, but if there are questions, I don't want to misunderstand. The second is issue number 2. And I'm here again on a commingling of issues on jury instructions. So the trial court, this is at volume 9, 1465 through 1469. The trial court starts talking about what is accomplice corroboration, accomplice testimony corroboration, and the law. Then the trial court went into when a person, a co-indictee, gives a statement to law enforcement after the conspiracy has ended, they've been arrested, that cannot be used against the other people on trial. So one of the co-defendants who did testify at trial, his name is Mr. Ash, A-S-H, He gave a pretrial statement, and it was totally exculpatory. It's that Mr. Fuller's not being truthful. It's that Mr. Fuller, by implicating Mr. Ash, is a liar. So it helps appellant. The trial court, though, charged at that point that can only be used for purposes of evaluating Mr. Ash. Now, remember, this is not some Crawford issue or Bruton issue where, oh, that pretrial statement can't be cross-examined. Mr. Ash testified. So, of course, that exculpatory statement could be used to benefit appellant. The trial court then went right back into defining what accomplice testimony is. Right after that, the trial court then went back and flipped over into this can only be used, the pretrial statement by Mr. Ash can only be used against Mr. Ash. The trial court then went into Miranda rights, which has nothing to do with appellant. He doesn't have standing for Miranda. The person testified. It doesn't matter if Miranda was violated. Maybe that helps Mr. Ash. It doesn't help appellant. And when Mr. Ash testified, it doesn't even help Mr. Ash. And then the trial court went into a confession needs to be corroborated. When the court reads it, I'm sure you've read it. This makes, I've had the pleasure of you allowing me to practice. This makes absolutely no sense to me. I can't get through this instruction and understand what's going on. But I can say this. It is loud and clear that there's error because the instruction that the exculpatory statement made by Mr. Ash pre-trial could not be used against anyone but Mr. Ash is just wrong. That is clear error because he testified at the trial. Once he testifies, then there's no problem letting in his prior statement because he can be cross-examined on it. But that is what happened here. With the paucity of evidence, as I hope I explained, in this case, appellant needed the jurors to understand that Mr. Ash made a prior consistent statement that Mr. Fuller is not being truthful by implicating the people. Mr. Ash did say that now at trial. His trial testimony was not tampered with, so that could go to the benefit of appellant. So I don't want to confuse or mislead anyone. Mr. Ash's testimony is in a position where it does help appellant, but only at trial, and the trial court excluded the prior consistent statement. Those are our issues. We have two other issues, but I think I talked about the accomplice corroboration was not
Very few
sufficient.
questions.
And then the only other issue is an issue dealing with co-conspirator hearsay and motive, but we briefed it. If you have no other questions, if needed, I was going to reserve the time.
Thank you.
No, thank you. Thank you for everything.
Ms. Pollack?
Yeah, that's what I thought, Aaron. That sounds right.
Mr. Chief Justice, may it please the court. Good morning. My name is Ruth Pollack. I represent the state in this case. I invite any questions by the court immediately. Otherwise,
Sorry,
I will follow.
Slow on the pause.
The caption always censors her name because it sounds like a slur for Polish people, even though it's literally spelled completely differently.
Good on Vimeo for trying.
Yeah, heart's in the right place.
Yeah, P for paucity.
Good
and yes,
work.
that was 0 questions.
Mr. Chief Justice, may it please the court. Good morning. My name is Ruth Pollack. I represent the state in this case. I invite any questions by the court immediately. Otherwise, I will follow my colleague, Mr. Steele's order of argument. I will first address his argument that the evidence of accomplice corroboration was insufficient in this case, and the state would submit.
Would you mind starting with the claim that the reference to the phone records of the defendants was an impermissible comment on the evidence?
Yes, Your Honor.
Because it's all sort of interrelated for the accomplice purposes.
Yes, Your Honor. So looking at the trial transcript, it reflects that
Does have
while
great hair.
the jury was deliberating, the jury sent out first a request for Google records in a prior note which they were provided, and then they sent out a written note asking for phone records. The trial court discussed what that meant with the attorneys, the trial attorneys, and then after learning that the records were being produced but were voluminous, brought the jury back into the courtroom and asked several clarifying questions. The court first noted that the jury had requested phone records and said that the court's interpretation of the note was that you wanted the phone records. The juror then said for those 3 days. The court then asked for all the defendants, and the juror said if that's possible, yes. So contrary to my colleague's argument that that is an impermissible comment on the evidence or an erroneous expression of the judge's opinion, it's very clear from looking at the context of the statement that that question was merely a clarifying question.
Well, it was, but it was, the thing it was clarifying was, do you want the phone records of the defendants? And it seems to me that the reasonable implication is then the records that were provided to the jury were the records that the judge believed to be the records of the defendant. I mean, is that not a reasonable implication?
Your Honor, in this case, the phone records for all of the co-defendants, including Mr. Larkins, had already been introduced into evidence. And as trial court testified at the motion for new trial hearing, he saw no problem with the question because he didn't think it was an expression of an opinion. It was only asking for clarification on what records specifically the jury wanted. So that was a strategic decision by trial court not to object. There was nothing objectionable about the trial court's question. It did not violate.
So the jury says, I would like the phone records of all the defendants. And the court says, here you go. Why is that not reasonably understood to be the court expressing an opinion that those phone records are in fact records of all the defendants?
Well, Your Honor, the jury is the arbiter of the credibility of all of the evidence, of what the witnesses say, and as well as the other evidence that is submitted. It was for the jury to determine whether they agreed.
I know, that's why there's this statutory prohibition on judges expressing opinions on what the evidence has shown.
But here, Your Honor, the transcript clearly demonstrates that that mere question for all of the defendants did not express or intimate any sort of opinion as to what happened.
Yeah, here's a trick for lawyers. Anytime you hear somebody say it could not be more clear, or it's obvious, or it goes without saying, or it is beyond serious dispute, it's they just don't have anything. That's what they're really saying. It's a weak point, and they're trying to just, say, oh, nobody could possibly dispute this because they don't have anything. Not always, but it's a red flag when you start hearing language like that. As I think this is a great example.
That's his question. Let's get his question.
For clarification on what records specifically the jury wanted. So that was a strategic decision by trial court not to object. There was nothing objectionable about the trial court's question. It did not violate.
So the jury says, I would like the phone records of all the defendants. And the court says, here you go. Why is that not reasonably understood to be the court expressing an opinion that those phone records are in fact records of all the defendants?
Well, Your Honor, the jury is the arbiter of the credibility of all of the evidence, of what the witnesses say, and as well as the other evidence that is submitted. It was for the jury to determine whether they agreed.
I know, that's why there's this statutory prohibition on judges expressing opinions on what the evidence has shown.
But here, Your Honor, the transcript clearly demonstrates that that mere question for all of the defendants did not express or intimate any sort of opinion as to what had or had not been proved.
Jim.
Yeah.
If
this
I
seems
ask
pretty obvious to
you,
me.
if I ask you to tell me what you had for dinner, and you tell me what you had for, it might be too early for lunch, and you tell me what you had for lunch, can I then say, you might have been telling me what someone else had for lunch? It's up to the jury to decide.
Yeah. See, I
Like,
think it's like this. It's like you're like, hey, show me all of the dogs that ate your food last night, and I do this.
dog demonstrative.
I'm saying that the dog ate my food last night.
Is this
That's
dog?
what that means. Like, what are we? This seems so obvious to me. I don't understand. Like, and that's not even like a simplification. Like, that's just what happened. It's like, give me all of X, and then the judge gives a bunch of stuff. Like, that means that all of the stuff is X.
Without an instruction on, can you clarify your question? If you mean this, we want to advise you that you are the trier of fact. It's up to you to determine whether or not blah, 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 these records belong to these specific individuals, these defendants. But they they don't give that curative instruction.
Yep. Yeah.
And yes, don't forget to hit that like button. Let's do the YouTube-y things. You did the intro, I'll do the YouTube-y things. Guys, don't forget to hit that like button. Thank you, Mary Debbie, for the reminder.
Oh, damn.
Please and thank you.
Mac and cheese and tater tots. That sounds good.
Yum. Yeah, what is everybody having for lunch and or dinner or breakfast, depending on where you are? Let us know. Let us know.
Tears of prosecutors.
Tears of prosecutors.
Those records were already before the jury, and there had already been other testimony provided by the expert witnesses as to whom
Did
the phone
counsel
numbers
for any of
belonged
the defendants object to the records that were given, being characterized as related to their defendant?
No, Your Honor, there was no objection to the trial court's question. There was no objection.
Which is why this is being framed as an
I
ineffective
see.
assistance of counsel
Yep.
claim.
Correct, Your Honor. And here,
Yeah, I think that's very telling that the judge is getting ahead of that question there. Like, he's thinking it's an error, and it might have been solvable if somebody had realized and clarified in that moment, like maybe through an objection or the court sua sponte realizing, hey, this could be misleading if we answer the question directly. Because, you know, you guys have seen, I think everyone here has watched a trial where there's been a jury question, and before they bring the jury in, they get a note. They pass the note to the bailiff brings it to the judge reads the question to the attorneys, and then they have the time to have like a conversation and think about like, well, should we do this? Do we need to do that? And nobody here did that. So you can frame this issue not just as it being a misstep to take the action of providing the records, but also the failure of the defense attorney for not objecting. And for him to even ask that question shows that, like, hey, I don't think this was right. Did anybody point out that it wasn't right?
Yeah. No, I don't think it's anything. Like I said, I think it's pretty obvious that it was a mistake. It's kind of, I'm curious to see how they rule on the ineffective assistance claim. Because it is kind of like it's like something you might not catch on the moment. I can see missing this in real time.
Yeah, maybe they'll, because they can lean on it just being the trial court erred, and or they can say ineffective assistance of counsel, which is a parallel claim.
Yep.
So I think they have IAC here. I'm actually not quite sure. I don't actually think the IAC claim is specific to this issue.
Yes.
At least from the heading.
Number 3.
Appellant's counsel failure to object to same. The court improperly commented on the evidence presented at trial. So is the comment the action of just giving? Is that considered a comment?
Yeah, that's what they're saying. That by like giving it, that was the comment.
Okay, now it makes sense. So I'm like, wait, there is one. Okay, thank you. Odd wording to me.
Yeah,
it's clear that trial counsel's decision not to object to that was strategic. That was not unreasonable.
What was the
Do you
strategy?
agree with your friend across the way's characterization of there being a genuine dispute as to whether these were the defendant's records?
Your Honor, it's certain that
Yes,
Mr. Larkin's attorney certainly argued that it was not his client's phone, not his client's phone records. It was for the jury to decide whether they believed that those records did belong to Mr. Larkins or did not belong to Mr.
That doesn't help,
Larkins.
though.
That goes to the very crux of what the jury determines. And clearly, they determined that those records did, in fact, belong to Mr. Larkins. And they
Or did the judge?
correctly found that those records, the cell phone data and the location evidence, which showed that Mr. Larkin's phone and the other co-defendants' phones traveled together from the Riverdale area to the location where the victim was shot and killed, and that those phones were in communication at the time that the victim was shot. That was sufficient corroborating evidence to enable the jury to find Mr. Larkins guilty of all of the counts for which he was convicted, and it was sufficient accomplice corroboration evidence. But in addition to those phone records and the cell phone location data, there was other evidence as well which corroborated Mr. Fuller's accomplice testimony, specifically the ballistics evidence that was found at the crime scene. There were 8 .45 caliber cartridges, or rather cartridge cases, and a .45 caliber metal jacketed bullet, which were among the evidence that was recovered at the crime scene. An expert later determined that those 8 .45 caliber cartridge cases had been fired by the same gun. And Mr. Fuller testified at trial that Mr. Larkins, the gun that he was carrying, fired .45 caliber rounds. So that was additional corroborating evidence.
But you didn't match the gun?
that
You just had the same caliber? That's pretty weak. Yeah, I mean, it's evidence, but it's not particularly compelling.
Supported Mr. Fuller's accomplice testimony. And finally, I would refer the court to the statement that was provided by Gerald Slaughter, both his testimony at trial and his statements that were made to the police. Mr. Slaughter, who was the witness who was asleep in the back of a pickup truck at the time that the shooting occurred, testified that he saw 3 people shooting at the car, and he told police that one of those men had crazy-looking hair. And the state introduced a selfie photograph of Mr. Larkins from his Instagram account, which showed his hair styled in a manner which the jury could have concluded matched that description. I'd cite to the court in support of that Barber versus State, 314 Georgia, 759 at 764, a 2022 case, that the jury could decide for itself how closely the description matched the defendant. So additionally, Mr. Slaughter had told the police that the shooters left in a red Impala and in a gold or beige car, which corroborated Mr. Fuller's testimony that Mr. Larkins was riding in the gold car when they went over to the area where the shooting occurred. Those 3 categories of evidence were sufficient to corroborate Mr. Fuller's testimony and authorize the jury to convict Mr. Larkins on all counts. I would next submit that Mr. Larkins hasn't shown any plain error in the jury charges. Looking at the jury charges as a whole, while certainly they could be clearer, they covered all...
You would not call these a model of clarity, right?
I would not, Your Honor. As
Peterson's on fire today. I like it.
No trial is...
Yeah, he has all of Pincer's energy. Pincer, all of his energy. Pinson. Let me get it correct. He has all of his energy today.
Yeah, Pinson's been quiet today. This is
every time he's been in the thing, he's been like this, like as if he's looking down. He might be doing more. There was a civil case that argued, and there was a bunch of amicus briefings. So he might be more prepared to inquire on those cases. I mean, just look at that. So he might be refreshing, sharpening his...
Yeah, those are interesting, actually. But I don't think that like other people would find them interesting. So I don't think I'm going to cover them. But they're interesting cases.
You never know. You never know.
It's perfect, and these particular instructions are not perfect. However, they are legally sufficient. They do cover all of the appropriate legal
Just get them right. I'm so tired of it.
The trial court charged the jury.
How confusing does an instruction have to be before before our application of the presumption that jurors follow instructions becomes unreasonable.
This is so funny because it's the same issue for the first case.
Exactly the same. And like, I don't think it's that hard. It's
I'm
not
not
that
sure that
hard to put together good jury instructions. Like in some cases it can be, sure, but like
When
it's
you
just a
try
lot
the
of
same
it's a lot of
statutes
work.
over and over, like
Yeah.
it should start to standardize itself.
Like it's very labor intensive, absolutely. But like clarity, I mean, they should at least be clear, even if they're wrong. Like you can just read them and see if they're clear. I don't know, but I don't get it.
Or if the
Yeah,
defendant is for a residence.
who hires the attorney for the appeals? It's usually the appellant pick. Well, I mean, if it's a criminal case, it'll be the defendant who picks their attorney. There are some people that get like public defender attorneys, although they have been kind of not doing the best job lately. But it's usually the defendant in criminal cases, and then it'll be either the district attorney's office or the state AG's office on the state side. And yeah, Moon Goddess, I really like Peterson. He's really good.
Jurors follow instructions becomes unreasonable.
Your Honor, I'm not sure that there is a bright line on that. Here, where the trial court included pattern jury instructions on all of these relevant issues, impeachment, on accomplice corroboration, statement by a defendant at a joint trial, voluntariness, credibility of witnesses, I don't think appellant has met the standard of showing that there was some obvious error in the jury charges. Even if perhaps they might have been clearer, they did cover all of the required legal elements. I would also point out to the court that Mr. Larkins hasn't shown that the outcome of the trial was affected by any supposedly erroneous jury charges. The reference to Mr. Ash's statements, there were a couple of statements at issue. The statement that he gave to police, he denied knowing the other defendants, including Mr. Larkins, and then said he knew some of them but didn't really hang out with them. At trial, he testified similarly. He testified that he knew of appellant, Mr. Larkins, and again denied knowing them personally. Then he said that he knew Mr. Larkins from going over to his house purchasing marijuana, and stated that he had been over at Mr. Larkins' house on August 3rd, but stated he wasn't there during the shooting. Those statements don't directly address Mr. Larkins' involvement in the crimes. They aren't exculpatory in any way towards Mr. Larkins, so I don't think that Mr. Larkins has shown that if there was any error in the jury charge, which the state does not think there was, he hasn't shown that the result of the trial would have been different when you look at what Mr. Ash's statements actually were. They just weren't that important. So I'd be happy to address any of the other issues if the court has any questions. Otherwise, I will waive the remainder of my time.
I don't see any. Thank you very much. Mr. Steele, I believe you have some time remaining.
Your Honor, I thought you said that maybe I misheard it, but I thought you said that the juror's note said, can we have the phone records of all the defendants? Actually, the juror's note, and I quote it, can we have the phone records? The only person who said for all the defendants.
Was the trial judge.
Right. And that's at record page 1981. So
Wasn't that to clarify what they wanted? I mean, isn't that a question to clarify? They said records, so that could be one.
That makes it worse.
2 records.
Your Honor, if I'm in a court and my defense is
They're not my records.
the bloody knife did not belong to my client, and the juror said, can we view the bloody knife? And the trial court said, oh, the knife that Mr. Steele's client used?
Well, that's only one knife in that instance, right?
But there's multiple people here.
That's not the point.
The trial court pinned every one
In
of
fact, I think her question is even more like left field, because there's also the issue of corroborating the accomplice testimony for the sufficiency argument.
Yep.
So it would be more relevant here. Oh, there's only one knife. But if there's multiple, that's particularly relevant to other issues that are being raised.
Yeah, true.
So
Mr. Steele's client used,
but maybe you
That's
just
only
got to
one
ask.
knife in that instance, right?
but there's multiple people here for phone records. The trial court pinned every one of the phone records on the people on trial. This is done. It is over. And the accomplice corroboration that you just heard about, there's no case in my memory that would allow that to corroborate. So the state said, and if I left something out, I'm not trying to, a color of a vehicle. The vehicle has no connection. So the accomplice said a vehicle color was this.
It didn't tie
Pam.
And an appellant was in it. That doesn't corroborate.
Thank you, Pam. Good to
anything.
see you.
The police found the color of a vehicle. There was ballistic evidence, certain type of shell casings. The accomplice stated these type of shell casings were fired by appellant. There's no firearm related back to appellant.
Yeah.
And they said that the hair is crazy. Well, I have been accused of having crazy hair at times. I mean,
That's
what is
false.
crazy hair? There's no identification.
You're lying.
This case is
Your hair
very
is always
weak
perfect.
until the trial court explained that the jurors are getting the actual piece of evidence that really corroborates.
Mr. Steele, didn't the detective connect the subscriber name of Quicksand with Mr. Larkin's residence on Ginger Court?
Yes,
Thank you.
but my cell phone records will come back to, I've been in your court for the past 30 minutes or so. So the fact that the records come back at a certain location are not admissible, and other people lived at appellant's residence. Appellant specifically said those records are not. That was a contented. That was the case. That was the issue in the case. Thank this honorable court, as always, for everything you do.
Thank you very much. Thank you to counsel for both parties. Well argued, and we'll get your decision within the time required by the Constitution.
There we go, you
Brian
guys.
Steele. Nobody has ever said that Brian Steele has crazy hair. That's I think that upsets me more of anything that's been said today. That's offensive to me, even more so than all the other stuff. Get out of here.
You were waiting to get that out.
I didn't even watch that part when I was doing the previous. I didn't even see that.
It's like the bookend of this. We started as soon as I hit the play button. You were like, "There's the silver hair," as Brian Steele walked from like down here. Can I draw on this? He was like over here. As soon as he came into the frame, you were like, "There's his silver hair." And here we are ending.
Did young Steele ever have different hair? Yes, he did. He had a baby face and brown hair.
Wait, we should schedule a time for that.
Yeah.
It's been like a month. That was like Christmas.
A separate thing. Do you guys there was like a prison war. I'm just learning about this like today.
Yes, tell us.
There was a prison warden in like 2023 at one of the Georgia prisons. I can't remember which one, but apparently he got charged with a RICO because he was like running like a criminal enterprise out of the prison, and he put a hit out on some of the guards, and he accidentally had the neighbor of one of the guards executed. It was like this old man, and apparently they like raided the warden's house, and they found that he had like hidden a bunch of stuff under a man-made pond. And it seems, I haven't been able to get into the details, but what I've read seems pretty crazy. I don't know if there's like
that sounds really familiar.
But yeah, there's a warden that's like putting hits out on people. And it was like, I think it was maybe partially in conjunction with one of the inmates who like had to pull in the streets, but.
Okay, wait. Georgia, Bryan Adams, not the singer? Is that familiar? Is this it?
Right. Yep, Bryan Adams.
Okay.
I was reading the DOJ report on Georgia
Holy
prison.
advertisements.
I think I saw this exact website. Yeah, Bobby Kicklater. That's right.
I'll take away the ads. Dang.
Yeah, he was trying to put a hit out on one of the guards and killed the neighbor.
Crazy. Rest in peace to Bobby Kicklater.
Great name.
Great name. All right, and they arrested 4 individuals: Nathan Weeks, Christopher Sumlin, Keisha Jones, and Ariel. Like, that's an interesting way to spell it. I've never seen it spelled that way. I'm thinking of the Roof that we
Airplanes.
just watched with the hair as Ariel the mermaid, and eventually uncovered a multi-million-dollar criminal enterprise operating from behind the walls of Smith SP in Glenville, not Glanville. At the center of the enterprise was a steady influx of contraband, including cell phones, designer clothing, jewelry, drugs, and other items, most often brought into the prison by complicit staff. Over the course of 2 years that followed the murder, additional murder victims were revealed, including Jessup's father, maybe, and commissary delivery truck driver Jerry Lee Davis, and another former corrections officer, Jessica Jean Gerling. Dang, they're just like taking potential witnesses out.
Yep.
Court records name other GDC staff who were targeted by the criminal enterprise and outline other staff who were arrested on related charges. Irene Moore, a GDC employee since March of 2020, was arrested in April 2021 for entering Smith State Prison with $29,000 in cash. While her vehicle, how thick, like, in hundreds, how much do you have to, like, conceal to walk in with that? Maybe not that much.
Yeah, I mean,
sorry guys, I don't have personal experience knowing how much that would be stacked up in cash.
I only know what it's like in one. I'm just kidding.
While her vehicle was being searched by GDC investigators, her cell phone received a call from an inmate using a contraband phone inside Smith SP. Criminal indictments and court records allege that Moore was romantically involved with at least one inmate at the time of her arrest. She was terminated by GDC following her arrest. The unraveling of the conspiracy culminated with the arrest of Warden Brian Adams and an excavation of the pond at his residence on GDC property, which revealed buried contraband. Weeks, Sumlin, oh no, familiar name, Jones, and Murphy were all charged in Kicklighter's death, among other things. Adams was charged with false statements and writings, violation of oath by a public officer, bribery, and criminal attempt under the RICO Act. So, are you going to follow this?
I don't know. I don't even know if it's like resolved. It might be resolved. I really have no idea. Oh no, that looks like it pretty recent.
Yeah.
But
Hold on.
I think I might do a deep dive on it. I mean, based on this picture, he's probably like 6'7", 6'8".
Oh my god. Let me look up.
But yeah, I don't even know if it's resolved. But I just discovered this reading I might do a read through of the DOJ report on Georgia prisons, based on how much has just the last like 4 to 6 months in Georgia prisons have been
Gotten worse.
incredibly tumultuous, incredibly bad. There were like three separate gang wars. They're actually in statewide lockdown right now after there's a riot 3 weeks ago, maybe, at Washington State Prison that actually involved. As soon as I said 6'7", I knew I'd said it, and I was mad at myself for like letting that be a thing. But yeah, there was a riot that spilled into the visitor center. So there were inmates that were like trying to seize the visitor center, where there were just like people that were not in prison visiting their families, and they got taken over. And I think there were like 4 murders that weekend in Washington State Prison.
Crazy.
There's another one last week as well at Macon, maybe.
It's hard to keep track.
Yeah,
and we have some ongoing scandal too down here in Brevard. There's like contraband. No deaths in the facilities, but there's a big contraband scandal like going in and out of the prisons, and that's unfolding over the last 2 weeks down here.
Yeah. Oh, also there's no heat in Georgia prisons, so
that sucks. It's been cold.
Yeah, I think it was down to like 30 degrees, 30, 40 degrees, like even inside the dorms.
That inhumane.
And they're on lockdown too, so they can't even like move around to get warmed up.
Actually, isn't that why there was someone hospitalized? They were trying to start a fire?
Probably. That sounds right.
There was a separate fire in a facility like within the last 3 or 4 weeks. I think AJC was reporting on that story. So just a hot mess.
That checks out. You see that Joseph Papp got laid off?
No, that he wrote about.
No, I mean I just saw a tweet that he's getting laid off from AJC. That sucks.
What? I know they were canceling their print division, but I mean I read all his articles online. He's the reason I pay for AJC. I'm canceling.
I canceled yesterday. Yeah, he just tweeted about an hour ago.
Oh.
But yeah, he's the crime reporter in Atlanta. I actually met him when I was there meeting with somebody for an appeal I was going to do.
Wait, I have notifications on for him and it's like drowned out. Guys, I'm going to drop his link in the chat here. You guys have probably seen me drop his link. If you use X, this is, if you haven't previously followed him, this would be a good time to. Incredible coverage. I mean, he's the reason we knew so much that was going on with YSL Trial 2 and the in-between of Trial 1 ending and the pleas and all of that mess. He was the reason we heard Diamante Kendrick at the plea hearing where Adam Abate said something to the effect of just say yes when it was time to confirm that he was going to accept a plea. He's the only reason we know that. So here's his link in the chat, and I'll throw on screen here. It's always the Z first in the name, how he spells it, in case you need to look up his name any other time. That way you have a visual of how his name is spelled. That's really sad news.
I liked him.
I'm going to have to... I'll repost this, but guys, keep your eyes open for anything you see and think of him if there's anything you see open looking for writers or that field. So... that sucks.
Maybe we can have him on. He can join the team. He's a free agent now.
Oh my god. That'd be fun. I'll teach him how to screw around with StreamYard.
Yeah. I said it as a joke, but like he might have like not been able to come on because of like media restrictions. Maybe we can get him on to talk about all of the dirty secrets he learned in YSL. That could be a cool stream.
That'd be awesome. I'm gonna like reach out to him just to be like, bro, I'm sorry. That sucks.
Hey, I guess I'm sorry.
As you said that, I was looking, I had this article open about the Bryan Adams thing, and I was about to harp on this number. Investigation, 360 Georgia prison employees arrested for smuggling contraband since 2018. And it's sourced back to AJC, and when I tried to open the article, it just, like, the article's not there anymore. It's not just paywalled, because I currently am still paying for AJC. That might change tomorrow.
Corrections Commissioner Tyrone Oliver, who refuses to answer my emails, even though, never mind, not a fan.
Oh, it was worse. Yeah, you're right, Adventure Aaron. It wasn't just say yes. It was yes gets you home.
Yep.
Thank you, Aaron. Yeah, that's an important correction because I think it's a big distinction. Also want to give an out loud shout out here to Pam Esquire, the law intellect. If you guys have been wondering what's going on, still doing ongoing coverage of everything going on with Milagro Grams and Megan Thee Stallion, updates on any appellate issues over there. Also and she went boots on the ground to that trial. So that was the type of thing that a lot of people were interested in. There were no cameras in the courtroom. So to get coverage, you had to find someone that was going in there in person. And she took the time out of her day to do that and do great recaps every night, which I always respect someone going in and just getting the information and sharing it with other people. In addition, just one of my favorite, easy to listen to, easy to learn from creators here on YouTube. Also, unlike myself, but like Jim, a practicing attorney. So here, go over, hit all of the likes on all of her streams and videos, hit that notification button so you can catch her when she goes live. If you like this chat, you'll like the chat over there as well. Very warm and welcoming. So
yeah, I was like having new, I don't know, I shouldn't say new, she's probably been doing this longer than I have, but discovering new people, because I think that in like LawTube, there's just a lot of, there are a lot of people that cover the same stuff, cover the same like handful of trials. And getting more voices, more subject matter is always cool.
100%. And I always like, you know, when there's like a group of people thoroughly covering one trial, I feel like, okay, well, let me cover something else, and then you know, I can go over and catch their coverage, because overall I can get diverse perspectives and feel like I can trust the information I'm getting. So I like being able to not have to do the deep dive and be able to rely on others that are covering cases, because obviously time is limited. So major appreciation. And we've got, I was going to say, I saw that Nick Starro was live. I don't know if he'll still be live, but he's actually talking about the Edric Faust case. So if you guys have been hearing about that hot mess,
Katt only covers chaos. True.
Huh? Yeah, I only cover chaos. Let me see if Nick is live. We'll stream snipe him for a second. if he's live still. He might be gone. You guys will find out when I end this stream if you're watching over in my chat if it takes you over to Nick Staro's channel. But a quick search, it looks like he doesn't have the red circle anymore.
Let's find like a tiny crime streamer and then raid them.
Hey, old folks.
Oh, he's got a bird on his shirt. Yeah, let's do that. Do you know how to set up a redirect, Jim? Or do I want me to teach you now?
No, no.
I'll say it out loud. You don't have to like share anything. I'll tell you how to do it.
Yeah, hold on. I don't have that many people watching right now though.
That's okay. Maybe they want to travel with us. They don't want to be left behind.
Okay.
So guys, tomorrow, by the way, I will be live tomorrow, continuing with the Edric Faust trial in Georgia. If you are looking for a trial to follow, I'd recommend watching opening statements at least. You should be able to catch the sides of the case from that alone. And start watching live if you want to. If not, try to watch on like 2 or 3 times tonight, get caught up. But not to play myself, but there's relics of Brian Steele in this trial. Thank you, DB, for this clip here.
Your Honor, I am again moving for a mistrial. We can't impeach witnesses. We can't argue consent. The state can present things that we can't present. We can't rebut allegations in their indictment. We are requesting a mistrial. This is not fair. This trial has been worse than practicing in communist Russia. He doesn't stand a chance in this courtroom.
Oh
the witness made a prior statement. We played the recording for the court. The witness made a prior statement. He was wearing like an orange colored shirt, orange or red, something bright. That is a quote. We played the recording. The Honorable Court was able to hear that recording. Her testimony here today was that he was wearing a hoodie. This is important because the state wants to make all the people that were seen in the neighborhood Mr. False. The person that they brought the first witness in for said, oh, he had a jacket. So of course they want her to say, oh, he had on a hoodie. It's an inconsistent statement. We are handcuffed, Your Honor. We are asking for a mistrial in this case.
It's been, yeah, a hot mess. Hot mess. We had double Sheriff Chucks on the screen there for a second, too. But seriously, guys, hot mess trial. It's not in Fulton County. It's over in Athens, Clark County. Cold case, 25 years old. Swabs that were mislabeled. Evidence envelopes that, when opened on the stand, were empty. Just a whole bunch of stuff. Oh, is misdemeanor live? We can do misdemeanor. And do you see how to do it back in, if you go to YouTube Studio?
Yeah,
and
I
then,
figured it out.
Yep, click the edit button for what you're currently live on, and then it gives you the option to customize, and then redirects at the bottom, you guys. So we're going to go over and hang out with Miss Janet Demeanor. Miss Demeanor, one of the greatest names in YouTube, I think. Where is... Okay. I had to type her full name to get it to come up. And say hey to Janet, hit subscribe. She covers a lot of trials as well. She recently did a primer, a 2-part primer the last 2 Wednesdays on the Corey Richards case. So with jury selection set to start, I think on the 10th of February, if you're interested in that trial and it's been off your radar because it's taking forever to start, she just did a primer this Monday and last Monday, 2 parts. So great coverage, great community over there as well. And we're going to wrap it up with there, you guys. We're going to see you guys in the morning if you want to hang out. Jim, we'll figure out eventually when we do the vintage steel.
Yeah, I keep forgetting about that. I'm going to write it down. I'm going to put it on my list. But yeah, listen.
Do the planning. The whole trial is available. I mean, not like outside the presence of the jury, but each clips of all of the witness testimony is available. So we could watch all of the trial that the jury would have seen, or we could just watch Brian Steele's opening arguments. So you make the call there.
Okay.
Cool beans. So keep that on your radar, guys. There might be eventually when we can all set a date, we might watch Brian Steele before he had silver hair. So with that being said, say hey to Miss Demeanor when we redirect over there. See you guys tomorrow. Thanks, Jim. Thank you, chat. Have a good one.